application of Smith against the Secretary of State for Defence and another.
Hello, Melody. Good morning. Two things before I start back in, if I may. The first thing is that we have made some preliminary inquiries in relation to the question of whether Private Smith was compulsorily called up or volunteered. It appears most likely, although we are still checking the file has been retrieved from storage, so the answer finally won't be with us until tomorrow. But it appears that the position in general terms is that there is a power to compel. Even those who volunteered are served with a compulsory notice, as it were, for the purpose of protecting their rights. But that at least in relation to those who aren't in what might be called the specialist disciplines, what the MOD do is to ask for volunteers first. And my current understanding is that at least in relation to the ordinary run of soldiery, there has not yet been a need to go beyond the call for volunteers. Although, as I say, there is a combination with that, because even those who volunteer are served with a compulsory notice for the purpose of protecting their rights. But we've got the file of Private Smith pulled out of storage, and they're checking the position finally in relation to him. Answer should be with you tomorrow. The second thing is that we have copied overnight for you, and I'm afraid there are yet more authorities to burden you with, but in front of you there are two or three further authorities, which I'm going to come to in a while if I may, but those are the copies of the cases that are referred to in paragraph 91 of Drodds that are not already in the bundle. When I get to that bit, I will give you the references to those that are already in the bundle, but those are the missing ones. My Lords, my Lady, could I start this morning with, very briefly, just to remind you of the fact that we have made submissions in our case on Gentle. Gentle, as you will recall, was the case in which it was, there was a call for effectively an inquiry into the legality under international law of the intervention in Iraq. I have very little to add to what is set out in our case on that respect. The case is in the core bundle at tab 3, and the relevant paragraphs are paragraphs 53 and following. Simply to note from paragraph 56 of the case that the point that the soldiers were within the jurisdiction because of the UK, it was asserted of the UK's power of command and control, was in fact argued before the House of Lords. See the references at the bottom, the final sentence of paragraph 56 in the case. So we don't accept that the argument wasn't made in the same way, which appears to have been a conclusion of the Court of Appeal. And that argument, having been run, was rejected by Lord Bingham at paragraph 8.3, 8 subparagraph 3 of his speech. Gentle is at bundle 3, tab 25. And we submit that that was an intrinsic part of his reasoning.
Paragraph 8 brackets 3.
Paragraph 8 brackets 3, it's in bundle 3, tab 25. 8 brackets 3 is the relevant paragraph.
So he's applying Alskany, in fact, is he?
He's applying Alskany. Yes. And you'll see the nature of the argument. That was run from, in the report, page 1362, which are the submissions of Mr. Sumption. In response, it's summarised relatively briefly in the opening of Mr. Singh at 1361 between letters C and D. There are then responsive submissions by Mr. Sumption on behalf of the Secretary of State, the relevant part of which appears at 1362 between the letters E and F. And then the reply submissions of Mr. Singh are at 1363 at letter G. Lord Bingham's rejection of those submissions and the application of Al-Skaney is, as I say, at paragraph 8.3. And my submission is that the majority agreed with him. See, so far as that is concerned, the references collected together at paragraph 63 of our case. So it's Lord Hoffman at paragraph 16, Lord Hope at paragraph 28, Lord Scott at paragraph 29, Lord Roger at paragraph 45. There might perhaps be a query about Lord Roger because he said these are, as I understand, the essential reasons given by Lord Bingham. And I think it's right to record that 8.3 didn't feature specifically in the reasoning of Lord Roger, so there may be a query about what was meant by essential. But Lord Mance at paragraph 74, and it's right to record that Baroness Hale
Yes, I was the odd person out.
expressing a slightly different view at paragraph 60.
Didn't I expressly say it wasn't necessary to decide? I thought I did.
Yes, that is in paragraph 70, I think. In the bracket. Between G and H.
Right?
Between G and H in paragraph 70, page 1384, in the speech of Lord Brown.
Whether required under Article 2,
yes,
your lordships
that's
do not need to decide.
Yes.
Yeah. I mean, we really didn't have to decide it, did we?
Lord Carswell. James.
Lord Carswell at the top of that page, paragraph 66, expressing the view that it appeared questionable, although also saying we didn't need to decide it.
Yeah.
I was conscious of the time. I'm not going to make more of Gentle. You have the references there. You're a body of 9. You can make of it what you will. We rely upon the speech of Lord Bingham in paragraph 8.3 and the agreement of the majority with him. What was my lady then? Al-Sadoun, if I may. I indicated that there's now a judgment on the merits that's been given, and that's in the white file. I'm not going to go to that for this purpose. What I would like to do, however, is to go to the jurisdictional reasoning of the European Court. And in order to do that and to understand it, it's necessary, if you would, to start with the Court of Appeal's judgment, which is in Bundle 2 at tab 20. You'll see the context of the case, which is important, from paragraphs, in particular paragraphs 6, 7, and 11 to 12. And what those paragraphs indicate, I'm not going to read them out now, but what those paragraphs indicate is that we are in the context of Al-Sadoun, post-handover territory, if I can put it that way.
We're in what?
We're in post-handover territory.
Yes, yes.
So governmental authority had been handed back to the Iraqi interim government.
In fact, I noticed, going back to Gentle, that Fusilier Gentle was killed on the 28th of June 2004, which was the very handover day, wasn't it?
Yes, it was, precisely that day.
Prior to that date, the legal position was that there was belligerent occupation.
Correct. We were an occupying force for that purpose, as one sees in particular from the opening paragraphs in the judgment of the Divisional Court in Alscaney, which is, as I said in the opening, the best place to go and find the legal regime which was operating then. But this is a post-handover case, so authority has been handed back, governmental authority has been handed back to the Iraqi interim government. And so there were various obligations under agreements recorded in paragraph 7 of Al Sadoun in the Court of Appeal to hand back those who were detained by the British forces. And you see a description in paragraphs 11 and 12 of the developments in the Iraqi criminal process, culminating in a request by the Iraqi authorities for Al Sadoun to be handed back pursuant to orders of the Iraqi courts. Paragraph 23 and following address the jurisdiction question. And extensively cite from Bankovic and from the various speeches in Alscaney. You will see from paragraph 28 that the Divisional Court had concluded that Al Sadoun was within the jurisdiction of the United Kingdom on the basis that he was a prisoner on a British base. And the Court of Appeal disagreed with that conclusion. In effect, holding that Al Sadoun was held in right of the Iraqis pursuant to the various agreements in place. And the relevant paragraphs to sideline are 33, 36, and then the relatively short reasoning in the judgment of Lord Justice Laws between paragraphs 37 and 40. Just to complete the picture, the Court of Appeal then went on to hold, in the alternative, as it were, that even if he had been within the jurisdiction, it wouldn't have been a breach to transfer him back to the Iraqis. And they applied the B case, which was the case about people entering the embassy in Australia, which I know my Lord Phillips will recall, in effect imposing a rather higher-looking hurdle for claimants to overcome than a straightforward real risk of ill-treatment test in certain circumstances where there might be a countervailing international obligation to hand back. And it was that was at least called into question in the judgment on the merits, but that's not an issue which needs to trouble the House today. But that simply completes the picture so far as that side of it is concerned. And the European Court of Human Rights, in their decision on admissibility, which did address the jurisdictional issue, disagreed with the Court of Appeal and concluded that Al Sadoun and Mr. Mufti were within the jurisdiction of the United Kingdom. The admissibility decision is in Bundle 5 at tab 44. We've been back to the observations that were put in by the applicants. They're not before the court, but the record of the essence of the arguments being run by the applicants appears from the court's judgment, in particular at paragraphs 71 and 73. Those are a fair summary of the arguments that were being run. If one goes back to the observations, you can see that particular reliance was placed on, for example, the Cyprus and Turkey case, which I'm going to come to in a while, and its statement that authorised agents of a state, including diplomatic or consular agents, remain within the jurisdiction and so on. But they were effectively running, as is recorded in 71 and 73, precisely the arguments that were run by Mr. Singh in Al-Skani in the House of Lords. One can perhaps do a contrast between the way in which that argument was put on page 160 in Al-Skani in the House of Lords, which records the nature of the argument being run by Mr. Singh. It is, to all intents and purposes, this argument: state agent authority is a very broad principle of personal jurisdiction. And they placed reliance on Issa for that purpose. And you will recall that it was that difference that effectively divided in Al-Skani the Divisional Court and the Court of Appeal. And the House of Lords concluded that the Divisional Court's reasoning was to be preferred. See in particular paragraph 127 in the speech of Lord Brown. So that's the argument that was being put before the European Court, and the Court's assessment appears between paragraphs 84 and 89. And the critical paragraphs are paragraphs 88 and 89. The Court considers that given the total and exclusive de facto and subsequently also de jure control exercised by the United Kingdom authorities over the premises in question, the individuals detained there, including the applicants, were within the United Kingdom's jurisdiction, and then they cite the Hess case, which you will recall was the case that was cited by Lord Brown at paragraph 132 in Al-Skani. This conclusion is, moreover, consistent, they say, with the dicta of the House of Lords in Al-Skani and the position adopted by the government in that case before the Court of Appeal and the House of Lords. And they say in the Court's view, the applicants remain within the United Kingdom's jurisdiction until their physical transfer to the custody of the Iraqi authorities. The question is whether the United Kingdom was under a legal obligation to transfer the applicants to Iraqi custody, and whether, if there was such an obligation, it modified or displaced any obligation owed to the applicants under the Convention, are not material to the preliminary issue of jurisdiction. So they are, in effect, disagreeing with the Court of Appeal on that narrow basis. They're saying the mere fact that you held them in right of the Iraqis does not move them outside your jurisdiction. They fall within your jurisdiction. But the reason they fall within your jurisdiction is not because of the argument that was being run there and was run in Al-Skani, namely a wide version of state agent authority. It is specifically because they are on the territory. There have been a number of occasions where I've appeared before this court recently with a Strasbourg authority horribly against me, and often a recent Strasbourg authority horribly against me. This is one of those rare and marvellous occasions where I can properly make the submission that this Strasbourg authority is thoroughly in my favour.
The jurisdiction in the Al-Skani case was relinquished to the Grand Chamber in January, and it's due to be heard by the Grand Chamber on the 9th of June.
It is.
Should that affect our approach to the question, given the centrality of Al-Skani?
My Lord, my submission that shouldn't affect your approach to it, because, as my Lord will be well aware, the process that occurs between this, the highest court in this jurisdiction, and Strasbourg, is a process of dialogue. And they have, in the specific Al-Skani context, the views clearly expressed of your Lordship's House, and it appears from Al Sadoun as though they were attracted by that line of reasoning. We'll find out whether the Grand Chamber agrees or not. But in my submission, that shouldn't lead you to any different approach. You need to recognise, of course, that the hearing is occurring in June, but it may properly also be said that even if, or almost whatever the result in Al-Skani, there will still be separate issues, as it were, that arise in this sort of context.
Well, we're familiar with the argument that there is a dialogue to be had between Strasbourg and national courts, and we confronted that in the case of Horncastle.
Yes.
But for my part, I'm somewhat troubled by the sequencing of the dialogue here, since your submission, central thrust of your submission, is that we should march step by step with Strasbourg, and your submission that we should anticipate that Strasbourg would not recognise an extension to the exceptions to the territorial principle. Now, given that the Grand Chamber is going to consider this and hopefully will define how to approach the question of exceptions to the territorial principle, I, for my part, am slightly anxious about our expressing a view in advance of what they may say.
My Lord, perhaps two answers to that. One, a practical one, which is that that could lead to very considerable delay if what is in my Lord's mind is effectively an adjournment until the Grand Chamber opines. The Grand Chamber's judgments can come out more or less quickly, but it tends to be less rather than more in most cases. And they don't have an enormous track record of producing judgments very, very quickly after hearings before them. I mean, no criticism.
So the hearing is on what date?
The hearing is on the 9th of June.
And when would one ordinarily roughly expect the judgment?
Well, 3 to 6 months. 3 is the very minimum. It's pretty rare that they produce a judgment within 3. They produced the Al Sadoun judgment very quickly, but it was a chamber, and there were very specific reasons for that, not least the difficulties with the interim measure application and the urgency of the case. But I suspect that on something of this importance, it would be very surprising if a judgment came out in less than 3 months, more likely to be 6. So one's talking a very considerable delay. The second point is that, to the extent that my Lord is worried in principle, as it were, about treading on the court's toes, that pass has to some extent, at least in Al-Skani,
Let me disavow any anxiety on that account. Does it matter at all that, although the issues in this case may not be entirely academic, they are to some extent moot?
Well, we had a bit of an exchange at the beginning of the case about the extent to which they were moot. I shall be making some submissions in the context of Article 2 about the proper approach that the court should be taking in that context. It's obviously a matter for the court. If it takes the view that they are effectively academic, then that may well affect the approach. But
yes, thank you very much.
It might be thought to be a shame if we were here and had all this argument in front of 9 of you, and for there to be, as it were, a 0 at the end. But if that is the conclusion you come to, that's the conclusion you come to.
Well, obviously, if it goes against the United Kingdom in Al-Skani, that fairly well scuppers your case in this case. But if it goes in favour of the United Kingdom, that still leaves quite a lot to argue.
It does. It still leaves the argument we're effectively having. It does. Because we are operating, the premise of our case is that Al-Skani in the House of Lords was correct.
End. That's the line in the sand.
Yes. My lady is right.
I mean, if you were to succeed here and then lose in Strasbourg in some months' time, although in a sense the legal decision here would be unchallengeable, the position under international law would be so plain that the consequences which we would have ruled on at issue 2 stage would, on the face of it, just simply take place.
That would possibly. We'd have to see how it panned out, but
I think the interesting question is if you lost here and won in Al-Skani, where would that leave us?
I suspect.
It is an intermediate case. This is an intermediate case.
It is. But it may be that whatever the Grand Chamber say, one side or the other is going to want to readdress it. I'm afraid this may not be the last you'll have seen of this issue, because almost whatever they say is likely to have some impact. I think the reason we entered into this territory was on the question, should those sorts of considerations persuade this House, in effect, not to enter into the territory? And my submission in relation to that, as I understand it, in common with the Council for the Respondents, is that you should enter the territory.
The real difficulty I have in looking at cases like Al Sadoun, indeed looking at the whole area, is that we're given a series of rather random exceptions without any explanation of the underlying rationale. At least Lord Justice Laws attempted to identify some factors which should be taken into account, but these exceptions are capable of being rationalised in a way which is unfavourable to your case. If you take the Drodds case and you take the limited explanation of the position regarding diplomatic or consular agents or acts on board craft or vessels registered in or flying the flag of a state, the theme seems to be that one state is under law exercising power in another state's territory over particular people. One can argue that that is the present situation. We were in Iraq under Security Council resolution, exercising power over our own soldiers there. I think your submission ultimately has to be, there's never been a case like this before, just leave it to somebody else to decide, because we'd be making new law.
Well, my lord, that's part of the submission, but there is a more principled objection to it, which is that none of those exceptions in any event decided that, for example, the immigration officer in X and Y in Switzerland was himself within the jurisdiction. Those cases are all examples of, if you will, agency, or perhaps in Lord Phillips' analysis, estoppel type cases, where they're exercising a particular species of jurisdiction with the agreement of the foreign country. In none of those cases do they reason back from their ability to put third parties under their authority and control to the proposition that the person who is exercising that authority on behalf of the state is himself and for all purposes within the jurisdiction.
It never arose. It wasn't material.
It's an a fortiori case, isn't it? I mean, it'd be rather bizarre if you could bring within your jurisdiction through your agent a third party like Mr. X in the Liechtenstein case or whoever he was. But the actual agent himself, who's presumably actually there under your control through his commanding officer, who's another superior agent, is not.
Is it helpful sorry, I was just going to suggest that it may be helpful to look at paragraph 73 in Bankovich, where this point is dealt with. It's quite short. It's tab 47 in volume 3, I think it is. Because it struck me that one needs to read all the sentences in that short paragraph to get to grips with what the point is. 73. And this is picked up by Lord Brown and quoted in Alskaney in his analysis, I think just verbatim. 73 in Bankovich. Because what I take from this is that the court is looking at the second last line at what customary international law is telling us, and just accepting, all right, there is customary international law or what international treaties have provided. And it's, I think, saying that because customary international law has dealt with the activities of diplomatic or consular agents, then the Strasbourg Court recognises that that is an exception to the territorial thing strictly applied. So the question which I was going to put to you was whether there is any customary international law that deals with the position about soldiers. I mean, that struck me as a crucial point, and I raise this because the respondent's case repeatedly refers to public international law, and I'm not quite sure what they mean. I'm sure Ms. Rose will explain, but the phrase customary international law struck me as a very important phrase which one needs to get into to understand what this exception is all about.
Well, my submission is that there isn't, and there hasn't been asserted to be any principle of customary international law applying to soldiers. So the answer, short answer.
But there's something even more compelling, which is a specific Security Council resolution. I'm not sure whether we got it, or a whole series, in fact, which authorised states to take military action in Iraq.
There can't be any doubt that a belligerent occupant has jurisdiction over its forces. It's slightly different in the case of visiting forces with the consent of the state where they are, because there are usually treaties which precisely define the limits of jurisdiction between the state whose soldiers they are and the state where they are. But the belligerent occupation, there can't be any doubt, surely, that the occupant has jurisdiction over its forces.
My Lord, I don't think we've ever asserted that there is no jurisdiction over the individual soldiers. There is jurisdiction for a whole variety of different purposes, including, for example, long-arm criminal jurisdiction. I don't want to repeat the submissions I've already made, but I go back to the proposition I made yesterday, which is that you need to consider what jurisdiction means in the context of this particular convention. And the critical thing in relation to this particular convention are the three controlling factors identified in Alskane, which I mentioned yesterday, including the ability to secure to the people within your jurisdiction all the rights and freedoms. So one comes back to that. And it doesn't necessarily follow, my respectful submission, it doesn't necessarily follow from the fact that you can exercise a particular species of person, can exercise a particular species of state authority abroad, that person is, for all purposes, within the jurisdiction of this convention, within the jurisdiction of the United Kingdom for the purpose of this convention. They are separate questions. It doesn't follow from the proposition that you have other forms of jurisdiction over the individual, that one can jump straight from there to the proposition that, therefore, for the purpose of the ECHR, that person is within the jurisdiction. And the Commission, in some of the old cases, for example, in Cyprus and Turkey, which I'm sure we'll hear more about, drew specific distinctions between the concepts of someone being under the jurisdiction, partly, or for various purposes, and being, quote, within the jurisdiction. It doesn't follow from the fact that you are under the state's jurisdiction for particular purposes, that you are within it for the purposes of this convention.
Is there any authority you can explain to us what it's talking about when it refers to these examples of diplomatic agents and what it really means when it says in terms of customary international law, that is the exercise of jurisdiction extraterritorially? I take it it's not dealing with just control over the officials themselves. It's what they're actually doing in the territory that's really being talked about, isn't it?
Yes, I think they're allowed, as it were, without clashing with the sovereignty of the foreign state, to exercise the functions that they're allowed to exercise.
Well, precisely that's the case also with an occupying power.
So far as consular officers are concerned, there's the further complication of diplomatic premises, which was really the pertinent one in B. Not the authority of the individual, but
authority
control
over the inviolability of the premises under the Vienna Convention.
I mean, interestingly enough, in this very basement, there's a protocol or whatever signed by the King of the Hellenes and others dealing with jurisdiction over foreign troops during the Second World War.
That is not a case, the premises is not extraterritorial exercise of jurisdiction. What I think diplomats and consuls are quite different from ships. The position with regard to diplomats and consuls, of course, is that in some respects, where they operate is regarded in very loose terms as being under the jurisdiction of the sending state. But what is really involved is that they are exercising functions which are state functions of the sending state, which normally would be contrary to international law because you're exercising state functions. So the international community and customary international law says those functions are functions which you can exercise in a foreign state extraterritorially. And it seems to me that what a belligerent occupant does is more parallel to that than the exercise of extraterritorial jurisdiction over ships.
Well, I accept that there are different legal regimes as a matter of international law that applies between diplomatic agents and and craft and vessels and so on. So there are two different regimes in play. And I accept also that there is, as it were, international legal permission to do various things as an occupying force and to do various things if you enter into a treaty, for example, after the handover of power in Iraq. But my short proposition, however, is that it doesn't follow from those species of jurisdiction and control and authority that one can reason back to the proposition that those who are exercising it fall within the jurisdiction.
I mean, Mr. Reid, is it right that in none of these cases, I mean, no diplomat, consul, or even possibly ship's captain or aircraft captain, and similarly, all these various people in all these cases, I collect up in paragraph 121 of Al-Skani, I mean, nobody discusses whether they individually, the people who are fulfilling these functions on behalf of the UK abroad and therefore bringing other people within the Article 1 jurisdiction, whether they themselves attract protection under Article 1.
They don't.
I mean, the point is simply not been decided either way in any of the cases. It hasn't arisen.
Yeah, that's true.
They are the state. Isn't that, I mean, when the people, the soldiers or the consular officials are in effect the state, isn't that right? I mean,
For the purpose of the
for the
exercise of those
purposes of
functions.
the jurisdiction. Yeah. The question then is somebody who's actually there as the state also does
As an individual.
within the jurisdiction somehow, or is he just there as the state, in effect, exercising the jurisdiction?
And does it follow
He's
from
doing whatever he's doing.
Does it follow from his status that for all purposes, wherever he is in the world, he carries what I described as the backpack of the ECHR on him?
Paragraph 73 is quite cautious, actually, because it uses the words recognised in the first and last lines. It gives examples, but I mean, one would want to know whether there was anything that actually recognised in customary international law what we're talking about in this case.
It's a rather controversial subject, isn't it? The basis on which the British were there, and if it were to turn on the question whether it was in accordance with international law, that would be an issue which neither side would be very interested in exploring.
Neither side has certainly invited you to explore that.
I thought it
Yes,
was...
well, on any view, they're belligerent occupants.
They are, and so
You invited, sorry, I didn't mean to interrupt. You invited our attention to the divisional court, and it does deal with it very clearly. And it's paragraph 11 of the divisional court in the White Bundle states very clearly the position, just as my Lord Collins has been mentioning it.
My Lord, yes.
I mean, I did in Al Jeddah too. I mean, where
You did. And a similar concession.
it's
was
very.
made in Algeria.
I mean, because as I recall, I mean, there was no doubt as to the situation, the legal situation, by the time we get to this stage.
Well, that might be a sensible moment to go to paragraph 91 of Drodds.
Yes.
And the authorities under that. Drodds is at volume 7, tab 61. Can I just give you references to start off with, so that you have them there if you need them. X in the Federal Republic of Germany is amongst the loose ones that you've been given this morning. So is Hesse in the United Kingdom. Cyprus and Turkey is in volume 6, tabs 57 and 58, in particular tab 57.
Tab what?
Sorry, my lord. Volume 6, tabs 57 to 58,
Okay.
in particular 57. X and Y against Switzerland is in volume 12, tab 103. W in the United Kingdom is at volume 12, tab 102. But there is a related case which you I think has also been supplied, which perhaps needs to be read alongside that, which is W and Ireland. There were two separate claims brought arising out of the same incident, one against the United Kingdom and one against Ireland. And my lords, can I ask you, if you would, because to write in some further references next door to those, as it were, because all these authorities, every single one of them, was analysed at some considerable length, both as an individual case when they were going through the cases seriatim, and in terms of the analysis that then followed in the divisional court in Alskane. So, for example, X in the Federal Republic of Germany is paragraph 128 in the divisional court in Alskane, which is in your white bundle.
This was Lord Justice Rickson.
It was. Hess in the United Kingdom is analysed...
Sorry, can you give me that?
Yes, 128 for the Federal Republic of
yes.
Germany. Hess, which is the next one, paragraph 138 in the divisional court's judgment. Cyprus and Turkey, paragraph 130. X and Y and Switzerland, paragraph 141. And W in the United Kingdom, paragraph 149. And just as some general propositions, we rather than my making the submissions, we respectfully align ourselves exactly with the analysis of the divisional court in relation to the nature and effect of those cases. And by doing so, we align ourselves with the House of Lords in Alskane also. In particular, we make reference, if you would take up the Alskane case in the divisional court, which is in the white bundle, tab 2. We particularly invite you to read paragraphs 244 through to paragraphs 274. That 5 or 6 pages draws together their earlier analysis of all these cases and the conclusions properly to be drawn from them. And we respectfully, specifically agree with the divisional court's reasoning at paragraphs 259 and 260, where they analysed, in effect, what Bankovic had done. In these circumstances, Bankovic was decided. Our judgment, Mr. Greenwood, is correct to call it a watershed. It was the first time that the theoretical and international law underpinnings of the doctrine of Article 1 jurisdiction had been considered. Succession of cases in the immediately preceding years had perhaps come to demonstrate that a broad and thus potentially worldwide approach to the extraterritorial exercise of personal authority or jurisdiction did not lie happily with the regional scope of the Convention itself. And that particular analysis is the analysis that is set out in their judgment at paragraphs 254, the preceding paragraphs, 252, even 251 and following, where they analyse most, if not all, of the cases that are cited at paragraph 91 of Drobbs, the cases upon which specific and particular reliance is placed by the respondents. I go back to 259. Succession of cases, that's those cases, in the immediately preceding years have perhaps come to demonstrate, and so on. These matters have begun to be considered in the cases on Article 56. That's about extending the Convention to dependent territories, but also in Søring's case, as well as the more recent Northern Cyprus cases. significance of the regional scope of the European public order, of the legal space or espace juridique, could now be seen to have both an exclusive and an inclusive dimension. Exclusive in the sense that it demonstrated the Convention set a legal order for Europe, where a common heritage was enjoyed, not for the world. It was inclusive, however, in that within the European sphere there was a need for particular care to ensure that the Convention standards were preserved, Cyprus and Turkey and Bankovic. It also followed from the essentially territorial aspect of Article 1 jurisdiction that the broadest statements in the earlier cases, and we would interpose to submit that are now being resurrected in this case against us, the broadest statements in the earlier cases could not survive as a driving force for the extension of Article 1 jurisdiction to anywhere in the world where organs of state parties might exercise authority. In the circumstances, the earlier cases were rationalised in Bankovic's case more narrowly as exceptional examples supported by international law and treaty provisions, such as the activities of diplomatic and consular agents and so on. And they noted in particular the width of the broad doctrine for which Mr. Singh submitted in that case. Effectively, his submissions are reproduced in the House of Lords. See page 160. And just specifically to pick up one case, which is referred to earlier on in the judgment. If you go back to paragraphs 133 to 135, you'll see a reference to the Cyprus and Turkey case, which again was one of the ones cited at paragraph 91 of Drobs.
Which paragraph?
Paragraph 133 and 135, citing from Cyprus and an early commission decision in Cyprus and Turkey. If I could invite you to read those two passages. You'll note that even at that stage and before they got to their analysis, there was a note of caution about the breadth of those principles in paragraph 136. But when they come to the analysis, that is an essential part of their reasoning that Bankovic in effect superseded and rationalised. And if you go from there, but just keep a finger in it, if you would, back to paragraph 258, you will see between just below C, in paragraph 258 on page 218, just below the letter C, in those cases, namely Loizido in Turkey and Cyprus and Turkey, we would conclude that the Commission's earlier broad personal jurisdiction approach in Cyprus and Turkey at two decisions and reports, 125, that's the one we've just been looking at, and Christosmos, has been overtaken and replaced by the special exception of the doctrine of effective control of an area, which now becomes, as we've said above, the dominant reasoning. Although there are passages in these cases which still reproduce in one form or another reference to a broader doctrine, it becomes increasingly clear that what is driving the rationale of Turkey's jurisdictional engagement is not the mere personal exercise of authority over persons or property, but its responsibility as the new military and, through its puppet regime, civil government in northern Cyprus. It may in a strict sense be outside the home territory of Turkey, but in a very real and practical sense it is a territorial or quasi-territorial doctrine dependent on control of the territory. And we respectfully agree with that reasoning. The breadth of the reasoning in Cyprus and Turkey that's quoted at 133 is effectively based on a theory of personal jurisdiction, we submit, which has been rejected by the Divisional Court in this case specifically, and by the House of Lords when it came to consider the issue in Al-Skani. And we note that Cyprus and Turkey in particular the passage quoted at paragraph 135 in the Divisional Court's judgment, that passage is not supported by the Commission. It's a Commission case rather than a court case, but it's not supported by any authority. It's simply a statement by the Commission, which then, as it were, becomes replicated in the usual Strasbourg way. But there is no authority cited to support that proposition. And in any event, you will note the distinction that is drawn, even within the quotation in paragraph 35, between those who remain under the jurisdiction when abroad and those who fall within the jurisdiction. Even the Commission were using those concepts under and within in contradistinction to each other. But it is that authority which is the base authority for some of the later Commission decisions, which then simply reproduce the same form of wording, W in the United Kingdom, and so on. And it's that that is exploded as a theory by the Divisional Court and then the House of Lords in Alscaney.
I'm sorry, I mean, going back to 135 and the Commission's quotation, I mean, I think you contrast under and within, but actually, I mean, if you gave full weight to that view, you fail. I mean, when it says not only remain, armed forces not only remain under the jurisdiction when abroad, and I think it is intending there to connote that they are themselves entitled to the benefit of the Convention under Article 1, besides bringing other people within it by the exercise of their powers abroad. But I mean, I understand your point. Actually, that reasoning, frankly, can't survive Bankovic.
Oh, yes. I should perhaps make it clear, a short point, moving away from Drods for a moment, if I may, that I answered a question from Lord Hope yesterday about whether we accepted that those who fell within the little pieces of England, as it were all within the jurisdiction. There is perhaps some caution needed in relation to those little pieces of England abroad, as it were. It doesn't necessarily follow that everyone who happens to enter the military camp, the pizza delivery person or the outside contractor who comes in for a specific purpose, by merely entering the camp falls within, which is why in our case we've also included the doctrine of exclusive legal and de facto control of the person. But it comes with that rider. Certainly within the United Kingdom, it would apply to all, but there may need to be a little caution, which you won't need to grapple with in this case, but I simply put down the marker. There may need to be a little caution in relation to territory abroad.
I'm not quite clear what the criterion then is. It is a sort of just a practical point that the pizza delivery person said just for a second or two, and you can't exercise any control over what he does or what's done to him.
Effectively.
Is it that kind of
point? That's the short point, but I simply put it down so one doesn't express the principle too broadly. I'm sure it will have to be explored in other cases. Indeed, there are certainly 2 or 3 in the lower courts that are coming up, which may need to explore that issue in the context, for example, of the embassy in Baghdad, where there are questions that might arise as a result of that.
In Alscaney, there was jurisdiction over Mr. Al-Musa because it was in a British base that he was tortured. If he'd been captured in the desert and tortured in a military vehicle?
Without.
No jurisdiction.
No jurisdiction.
You're trying to have your cake and eat it to some extent, aren't you? I mean, it's a simple concept to say, well, control over territory makes that territory a little England so far as the convention is concerned. But the minute you say, provided, of course, that there's also personal authority, you're then introducing this concept of personal jurisdiction.
Well, to some extent you are, and I mean, I can put it this way: I'd rather have the cake and not eat it.
Yes,
if that makes sense. Yes. If this is the problem, then we'll stick with the territorial. Yes. But I simply add that in to indicate that there may be other issues that will need to be thought about in that regard.
I mean, is the one category you can't strictly fit into territorial, what I think I collected as the irregular extradition cases?
Well, I think those are the most difficult, I have to say. Those are the most difficult.
I mean, I think the Divisional Court in Alscaney, I've forgotten now where it is, but they suggested, that whatever he's called, Sanchez Ramirez, something to do with the fact that it's a French aircraft, but I'm not sure that works, does it?
I think you had that debate in the House of Lords in Alscaine, and that is quite a difficult basis on which to rationalise them. Yeah. And they do exist as a true exception, perhaps, which I think was the way that my Lord analysed them in Alscaine. Yeah. And as I said yesterday, that we'll try and produce some examples of practical distinctions. I'm not sure how far we've got on that, but perhaps die in the attempt, as it were. Before I go to them, it's as well to bear in mind that when dealing here with the difficulties of securing the rights and obligations under the Convention to soldiers, the argument against me is in effect that they are within the jurisdiction because of the degree of authority and control that is exercised over them, and so it applies to them as soldiers because of their status as such, and is said to apply to them off base, wherever they may be, and that is the context against which these examples are to be seen. And that does, in my submission, raise a series of problems in relation, for example, to any of the qualified rights that exist under the Convention. For example, freedom of expression. There may be stricter laws in place in the local region, and it may be impossible, in effect, to guarantee equivalent rights in the foreign state. Now, it may in theory be possible, and it was perhaps this I may have not adequately explained the thought that I think my Lord Phillips had yesterday, but it may be possible perhaps to rely upon paragraph 2 of some of those articles by way of justification for limiting the rights in that way. But the difficulty is that if one tries that in certain situations, which aren't difficult to posit, you end up in effect destroying the content of the right itself. And so any qualified right in my submission is problematic, be it it might be thought, European-driven and relatively expansive view that is now taken about family life and private life, or freedom of expression or freedom of assembly. All those things depend upon the state being in a position through its framework of laws and its controls to deliver those values, those freedoms and those rights. And if, as a matter of status, soldiers fall within the jurisdiction, that becomes a problem. I gave the example of freedom of speech in the marketplace in Kabul. One could take another example, Article 2 procedural, which is perhaps a little closer, but suppose, for example, a soldier is killed off base in a riot in Basra. Now, if that occurred within the United Kingdom, there would be a series of obligations which would cut in onto the state by way of a procedural obligation. They would have to secure the evidence at the place concerned if the riot happened in Trafalgar Square and led to the death. They would have to have the power to summon witnesses, to bring the perpetrators to justice, and so on. There are a whole series of practical and legal matters that would need to be dealt with in order effectively to deliver the Article 2 procedural rights that simply can't be delivered. But again, that's no more than an expression of the fact that in a foreign jurisdiction, for a whole variety of reasons, practical and legal, there simply is not the framework, the protective framework of laws that would be required to deliver those rights properly. Final point on jurisdiction, then I'll move on to the Article 2 issues, the in and out of jurisdiction concern, which I know was a matter which concerned the Court of Appeal to some considerable extent. I've touched on the submissions that I wish to make on that shortly yesterday. The fact is, in my submission, that jurisdictional concepts do involve setting hard set, relatively clear lines. That's the nature of it. If you're going to draw jurisdictional lines on a territorial basis, and everyone is agreed that this is an essentially territorial beast that one is dealing with, then that will involve drawing hard set lines. And the House of Lords in Alscaine, we respectfully submit, recognised that and accepted that the jurisdictional writ of the ECHR ran within but ended at the gates of the British military camp, so far as third parties are concerned. And it would therefore be possible on the reasoning of Alscaine to posit just as difficult an example, not involving a British serviceman, but, for example, involving the failure to wound an Iraqi person picked up on the battlefield who comes into the jurisdiction, and certain obligations then arise because he's in the camp. You can't just leave him bleeding to death on the ground within the camp. But suppose that there were, as it were, causal questions that arose because you'd also failed, or the allegation was that there'd been a failure properly to treat him off base. So it's inherent in the nature of the reasoning of the House of Lords we respectfully submit in Al-Skani that these relatively hard lines are drawn. And once you draw them, that will necessarily raise the sort of difficulties that I've just indicated.
I mean, it arose with Bahamusa because he
did.
was first picked up in that hotel or whatever.
It did. And it leads to some degree of odyssey. It may perhaps be thought that the difficulty in the Bahamusa case is, as it were, less difficult or potentially less difficult than some issues that could arise, because if you're dealing with Article 3, if you're beaten up off base and it's out of the jurisdiction, that is, of course, unforgivable and unfortunate. But that mere fact, as Lord Roger pointed out in Al-Skani, is not sufficient to engage the ECHR jurisdiction on its own. We're back to paragraph 64.
Well, is this any different from somebody coming in and out of the United Kingdom?
My lady, no.
Under the Channel?
I think the same would apply.
At what point, if I take Eurostar to Paris, do I cease to be in the jurisdiction of the United Kingdom? When do I come back? It happens all the time, doesn't it?
It does. And that is simply a function of jurisdiction being territorial. And so one would have to grapple with those. As I said in opening, there are potentially two aspects to it. There's the what I call the investigative aspect, which I'm going to come to. Does it impact on for example, the scope of the inquest? But there is also what may be called the cause of action aspect. What happens if you've got, as it were, causes that go along and there is either the Channel or the prison gate in Iraq that interposes between those, and it might be thought that that is not an uncommon problem. The solution to it might be thought to be to focus on what is the predominant cause in that respect. But those are simply functions of drawing territorial or geographical lines, and it's an illegitimate species of reasoning in my submission to say, well, because those difficulties arise, therefore one should move to a species of jurisdiction which is not geographical. That, in my submission, is not an appropriate form of reasoning.
How does your territorial thesis work with the supply of equipment?
What?
You supply a soldier with a defective rifle within the camp, and out he goes. And because it's defective, he's killed. Sirring, you expel somebody, or Strasbourg says, well, we're focusing on what's happening within the jurisdiction, although the consequences are outside it.
Well, I think that is an issue which is obviously quite a hot issue.
Yes.
And hasn't, I think, yet been fully considered by
Yes.
the courts.
Yes.
And what I say now may have to be qualified by cleverer people who come later and run a more restrictive argument. But one can certainly see a powerful argument for saying that if the decision in question happens either within the territory of the United Kingdom, because it's decided there, or within base, then that is sufficient to bring it within the jurisdiction of the United Kingdom.
What a decision to send somebody out in an emergency in a vehicle which is recognised to be insufficiently protective, you accept is covered.
Well, if one can tie the decision and the provision back to something which happens within the jurisdiction, then you have, at the very least, a powerful argument under...
It's a Sirring type argument.
It's a Sirring type argument.
So if you go to the quartermaster's stores, as has been suggested, and issued with an appropriate rifle, and it turns out to be defective, that's happened on base and would have the consequences,
Yes.
Irrespective of where the
Yes.
defect produced its result.
Yes. So one can see a perfectly powerful argument for saying that that should be within the jurisdiction. I mean, there may be other difficulties that arise out of that sort of area, which is our difficulties of allocation of resource and how one goes about doing it. And there are all sorts of potential difficulties inherent in that, which is why the concession is not made full bore, as it were, because they haven't been properly worked through in this case, because it's not necessary to do so. But as I say, if I can leave it on the basis that I can certainly see a powerful argument for saying, if you can tie it back to a decision which happens within the jurisdiction, that would be sufficient.
I'm sorry, I'm a bit lost here. I mean, take the current run of inquests which are held into military personnel who brought back,
Yes.
well, they're in Oxford or wherever it is. I mean, do they look at equipment? I mean, I think we know they look at equipment, but are they, in that regard, to use this ugly shorthand, are they a Jameson or a Middleton type inquest insofar as that dimension is concerned? I mean, do they investigate the inadequacies and allocate blame and all the rest of it?
I think they do, and I think they do, at least in some cases, as Jameson inquests. I'm going to come to that in a moment, but take, for example...
No, the Middleton inquest would be required if it's, on the face of it, if the decisions about equipment are taken, so to speak, on base or indeed back in the UK.
Well, I'm going to come to those issues in a moment. We wouldn't necessarily accept that, but even on a Jameson basis, they do examine...
Well, Jameson, you can range as wide as you like. It's a question of what
the
sort of a verdict and what sort of factual conclusion.
And I'm going to come to that in a moment. But simply on your factual question, do they currently look at equipment? The answer to that is yes. I did a judicial review not very long ago in relation to snatched Land Rovers, where the claim was being made for a public inquiry. And there was an examination, therefore, as part of that, of the inquest that had occurred. I think I'm right in saying it was a Jameson inquest, but I'll be corrected if I'm wrong on that. But they certainly did look at why snatched Land Rovers were being used for the particular operation in which the serviceman had been killed by an IED in Afghanistan. And they did examine whether there were enough there, whether it was an appropriate vehicle to be used for the particular purposes. I think from memory there was a line being drawn on the very broad policy issues about whether or not sufficient lead times have been given for getting these vehicles, but they certainly examined whether or not this was an appropriate vehicle in the particular circumstances and with the particular operation in question for sending...
Not merely examined, but proclaimed the juror's verdict on it.
Well, my lord, I'm going to come to it.
Yes,
I don't want to keep saying that. It sounds thoroughly defensive. But this inquest in this case, which was a Jameson inquest, stands as a pretty good example of what can be done. It resulted in what was called a summing up, but what was in effect an 8-page judgment with, I think, a 5 or 6 line verdict at the end from the coroner, which included the word serious failure, and all that had preceded it examined all the potential causes of Private Smith's death. There is considerable latitude for investigating those sorts of matters, and this very inquest provides a pretty good example of precisely what can be done, even in a Jameson inquest. My Lord's Article 2 inquest, if I may.
Can I just catch you before you go there? There's just one paragraph in the respondent's case, paragraph 50, that I just wanted to be quite clear about. You'll see that there's, I think, a criticism of your approach, which I suspect, having listened to you in the last day and a half, is misplaced. It said that your submissions are based on the erroneous premise that the claimant's case is that Private Smith fell under the second category, which you see over the page at letter B, that's agent authority and control, whereas the case for the claimant is it's the third category, which is personal jurisdiction. I think you've been covering all of these. You're not confined to the particular point on the second category at all.
No, and we say he fell within the jurisdiction because he was in the military camp.
Yes. So it's really 3.
Yeah.
Yeah. All right, thank you.
We say he effectively fell within the Al-Skani concession.
Yes. Yes.
So by analogy with Hess, see paragraph 132 in the speech of Lord Brown in Al-Skani.
Thank you.
Now, the Article 2 inquest, if that would be convenient. Just by way of introduction, you will have seen there is to be a new inquest. The new coroner will need to consider all the material as it is presented and indeed as it develops before him. He is not bound by previous evidence or previous rulings. And the decisions about scope and about evidence, and to some extent within the legal boundaries about verdict or inquisition, will be for him. the Secretary of State has indicated that he will not seek to trammel the scope of this fresh inquest by reference to the Middleton and Jameson differences, if any. And so the scope will not be restricted and can travel across, in effect, any territory the coroner considers appropriate. The second issue that is raised before this court is whether or not that inquest has to be a Middleton inquest, whether Article 2 requires it to be in that form. And one view, the short answer to that is that that's a matter for him, recognising the Secretary of State's stated position. I'm going to come back to inquisition and verdict in a moment. So the concerns that are raised are not so much as to the decision on whether or not this inquest is Middleton, as it were. The Secretary of State is content either way. The concerns are rather about the broader approach and principles to determining in this sort of case when Middleton is required in a context arising out of military operations abroad. And there is specific concern about the manner in which the Middleton answer was arrived at by the lower courts, which potentially impacts seriously on broader issues relating to the circumstances in which the state may become liable under Article 2 in such a context. In other words, the scope of the protective obligation, including especially the suggestion that one can simply transpose the Osman approach into this context. May I start with some very basic principles? It's well established that Article 2 contains substantive and procedural aspects. There is some overlap between the substantive and the procedural, and that is because the substantive obligations include, in addition to the negative obligation not to take life without justification, a positive obligation to provide a protective framework in domestic law, described by Lord Bingham in a summary which I think has never been doubted in Middleton, Bundle 3, tab 31 at paragraph 2, Bundle 3, tab 31 at paragraph 2, as a duty to, quote, establish a framework of laws, precautions, procedures and means of enforcement. The procedural obligation, in essence, that's in contradistinction to the substantive obligation, if there is any great difference between them, the procedural obligation is to initiate an effective investigation by an independent body or person. And its application may well therefore focus on very similar strands of process, for example, criminal or disciplinary, that are focused on when considering that substantive obligation, the positive substantive obligation. This is an issue which this court has been troubled with on a number of occasions in recent times, and so has the Court of Appeal. And we respectfully submit that the three critical authorities for your purposes are L, which was a prison custody case involving an attempted but unsuccessful suicide resulting in serious injury. That's in Bundle 3 at tab 29. Takushis, which is a Court of Appeal decision, which is in Bundle 3 at tab 32. And Hurst, which is in Bundle 3 at tab 27. Moving from the basic to the rather more specific in terms of the principles, we respectfully submit that the insight that the House of Lords provided in the L case was this, that there are two strands of issue in considering the investigative obligation. First of all, the trigger question. In what circumstances an investigative obligation of some kind is triggered by Article 2, or whether, as it's sometimes put, whether Article 2 is engaged. And secondly, the content question, which asks what is required by way of process in order to satisfy any such investigative obligation. And it is important, we respectfully submit, to be clear that they are, although linked, discrete questions. The temptation is to say that if the obligation under Article 2 is triggered in any particular context, it must be an investigation in a particular form, or it must comprise particular strands of a process. That is not so, as L makes absolutely clear. Article 2 may require some form of investigation. It does not necessarily have to be the same form or have the same content in all circumstances. And it certainly doesn't follow from the fact that Article 2 triggers an obligation to have some investigation that an inquest, our specific context, will have to be a Middleton inquest as opposed to a Jameson inquest. So one needs to be very careful about concepts such as an Article 2 inquest, which can serve to confuse, as it were, those separate issues, trigger and content.
The Article 2 framework to which Lord Bingham referred would presumably encompass the requirement to have a death certificate in the case of every single death.
Yes.
That's the first stage of the inquiry.
That would be an aspect of it.
Yes.
Yeah, it would. The other thing that it may be thought appears relatively clearly from L and from Takushis and so on is that although they are discrete issues, those, the basic principles that apply in relation both to trigger and to content are essentially similar in both contexts. There's been, as it were, a meeting in the middle ground, I think. In the early cases, there was a massive argument about there being something, a very important, sharp distinction between, on the one hand, the healthcare line of cases, and on the other, the custody line of cases. What appears to have happened, and the drift certainly in our respectful submission of the recent case law, is to search for common principles as between those contexts, with the differences between them being matters of application rather than matters of strict principle. So far then as trigger or engagement is concerned, in the custody context, in the L case, the House of Lords rejected the Secretary of State's case that what was needed was an arguable breach of a substantive obligation, in that case, as in many, to take reasonable steps to protect a person who presents a real and immediate risk. It was held that in the context of near suicide, leaving the possibility of long-term injury, there was an automatic trigger of the Article 2 obligation. And that was, in summary, because the rationale for the investigative obligation are not restricted to ensuring state agent accountability. They extend, for example, to ensuring that lessons are learned. See, for example, paragraph 29 in the speech of Lord Phillips in L, citing the well-known passage in the speech of Lord Bingham in Armine at paragraph 27. And secondly, because in any event, whenever such an event occurs, it is, as Lord Roger put it in L, at least possible that prison authorities had failed. See paragraph 59 in the speech of Lord Roger in L.
At least possible that what?
At least possible that the prison authorities had failed to take appropriate steps to protect. It being well established that in the prison context there was an Osmond-style obligation to take reasonable steps to protect against those known who were known or ought to have been known to be a suicide.
So that's just a watering down of arguable breach, really.
Yes, I mean
Just saying it's always arguable that there may have been.
exactly.
So you don't have to start by proving your case.
Yes. And there was an element which we recognise of what I might inelegantly describe as cart before horse. How do you know if they failed until you've had the investigation? Seems to be the thinking. So there are a variety of understandable reasons for the rejection of that proposition in that context. Similarly, however, in the healthcare context, the Court of Appeal decided in Takushis that Article 2 is likely to require at least some form of investigation in circumstances where death has occurred of someone whilst in the care of the state. And it may be worth just having to Crucius open, if you would. It is at bundle 3, tab 32. Paragraph 92. The court in that case has analysed the well-known line of authority dealing with the healthcare cases in Strasbourg, Karl, Siemensky and so on. And in paragraph 92 they say, as we read the judgment, that's the judgment in Siemensky and Poland, the obligation to investigate did not depend upon the state being in breach of Article 2, but upon the fact that the death occurred in the care of the state or in circumstances in which a servant of the state was arguably responsible on the ground of, say, negligence. And see, to similar effect, the Court of Appeal agreeing with the analysis of Mr. Justice Richards, as he then was, in paragraphs 95 and 96 on the opposite page.
But I mean, there's going to be an inquest anyway, isn't there? Or
there is.
I mean, in all these cases of deaths in hospital, in the Harley Street Clinic, I mean, you have an inquest, don't you?
You do. The question is what form, ultimately, which is where the Court of Appeal end up here. But here they're agreeing with the proposition that the investigative obligation may be triggered, we're still on the trigger for the obligation, may be triggered in a case of death by something which wouldn't be a breach of Article 2. So, for example, blind analysis in the Savage case, simply an isolated act of negligence in a hospital, despite proper systems being in place, which is well recognised would not amount to a breach of Article 2.
Is there an inquest in the case of every death in hospital?
No, surely not.
No.
If a patient's under the care of a doctor when he or she dies, and the doctor certifies the cause of death, isn't it?
It wouldn't automatically be.
I see.
Only if it's an unnatural death, I think. I was just trying to recall the jurisdiction.
If there was an inquest for every death in hospital, I think we'd need rather more coroners than we currently have.
No, that's plainly right.
It's unnatural death, I think, is the species.
But we have to distinguish in the positive obligation in Article 2. There are two kinds. I mean, forget the procedural one, the substantive one. There's the systemic one, to have proper systems in place.
Yes.
But there's also the one owed to an individual of the Osmond type, where you've got a sufficiently strong reason to suspect this person's life is in danger. You have to take specific steps to protect that person's life.
There are those two species
of obligation
inherent in Article 2. The question is, no one, I think, denies in this case that the protective framework obligation, the first of those, is in play. There is, however, a very live question as to whether or not Osmond should extend to all risks that soldiers face. But my lady is entirely right that those two are inherent in the substantive obligation. But there is, just to conclude this...
I mean, at some point, I do invite submission on the question of the interrelation between that systemic failure under Article 2 and the negligent duty of care, the sort of what you call Beechey case, the recognised duty of care which the Ministry has in any event in negligence to its forces both at home and abroad.
Well, I'll come to that. I'm going to have a section on whether or not there is a substantive obligation to go further and to have the Osmond type.
But I mean, Osmond wouldn't include anything to do with equipment failures, would it? Well, I suppose it.
Arguably, it might.
Yes,
I think the argument against me would be, in a future case where this arose directly, the argument against me would be soldiers face real and immediate risks in effect all the time when there are military operations abroad, so you're obliged to take reasonable steps, and reasonable steps include providing snatched Land Rovers or a different species of Land Rover.
That's a systemic situation rather than a particular risk to a particular person, isn't it?
Well, there is a question as to where one stops.
It isn't this case. We're talking about the extent of the procedural obligation. We've possibly got enough on our plates.
It isn't this case. But we recognise that in relation to the trigger for the Article 2 investigation, the trigger is a relatively light one, as a result in particular of the House of Lords analysis, including in particular the speeches of Lord Phillips and Lord Roger in the L case. The trigger in the case of death, at least, is relatively light. I think Lord Roger in L was positing the possibility that it wasn't unlimited, because there may be circumstances which someone who's attempted to commit suicide was perfectly able to give instructions to their lawyers, and there may be circumstances in which, even in that context, it wouldn't be necessary to have any sort of Article 2 type investigation. But we recognise that in the case of a death, where those sort of considerations don't apply, the trigger is a relatively light one.
Is that right? I thought that some significance might attach to the type of death when we're talking about a suicide or a murder in a situation of detention. There are specific and well-known risks of that type of death, and that type of death is particularly unsatisfactory and ought to be, if possible at all, avoided. I thought that was the special features. You say that any death now involves a relatively light trigger for an full Article 2 investigation.
Well, that appears to be the reasoning of the Court of Appeal in Takushis, which is that you don't need to link it back to anything if there's an arguable case of negligence of any kind, even if it wouldn't involve a breach of the substantive obligation. There is an obligation to have an investigation of some kind. I don't for a moment say that there isn't.
I mean, that was a suicide case. Sorry.
It was.
Yes, I mean, again, and the person had been identified as a suicide risk, and although not in captivity, it was actually taken to a hospital for treatment. So I would have thought again there might be a special type of situation.
Well, my Lord, I'm not closing the door on there being a special category of person, i.e. the person who is within the custody of the state or detained, or a special category of person in the sense of a well-known and immediate suicide risk. And I'm going to come back to that in the context of the content. All I'm saying, perhaps under this heading, is that it doesn't terribly matter, even if you were to conclude that the trigger had been pulled, there would still be a very live question as to what the content of the investigation would need to be.
I'm very unhappy with this concept of triggers at all in the context of what does Article 2 require. It seems to me it ought to require something much more flexible. Stage 1, somebody's died. Is the death natural or unnatural? Strasbourg would say you can't have a system where you don't even ask the question. So that's your first investigation. Why has the person died? If you decide natural, what does that mean? Well, as a result of, or not as a result of any human act or omission, perhaps. No need to look further. If it's unnatural, then there's a requirement for an inquest. The nature of the inquiry that then has to take place ought to depend upon the particular circumstances, the questions that are actually raised by the facts that need to be answered.
My Lord, it may be that I've tried to be over-analytical about the effect of the speeches in L, but we are, I suspect, very much on the same page, because most of the analysis as to what is required will fall under content if one applies the principles and approach set out in L, and indeed in Takushis. So it may not matter if one analyses it strictly as trigger versus content or all content, depending upon the circumstances. The principles which I'm going to try and draw from the case law which apply under content could equally well apply to a unified approach, if that was a preferred analytical approach. My only point is that it is tempting to say trigger, therefore Middleton. And that, on any view, I would submit, is the wrong approach. Even if trigger exists as a separate analytical stage, the true issues are going to arise under content, in my submission.
Does one need to know more about trigger than the last sentence of the quotation from Erickson in Takushi, paragraph 91, just that last sentence, which is describing the procedural element. And it's assuming that this is a death for which the state or its agents potentially bear responsibility. And if that's the position, well, that should be subject to, and it's put very generally, an effective investigation and so on, so the facts are known. But that doesn't take us to the point you're really coming to, which
doesn't take
is
us to the heart of it, which is what form?
Yes,
what form?
Indeed.
I mean, paragraph 92 isn't really terribly good, is it? Because there it says the obligation to investigate didn't depend on a breach, but upon the fact occurred in the care of the state. Well, I mean, as we've now realised, I mean, that isn't of itself going to be enough. I mean, there can be natural deaths in the care of the state, and they don't trigger any obligation. So you then go, it's in circumstances in which arguably responsible. And so there are cases, although L wasn't one of them, because that's a custody case where there is, so to speak, a duty in the first place, and that carries with it the investigative obligation. But there are cases where you do need to have an arguable responsibility, possibly. Is that right?
Oh, yes, and I think that is all of a piece with the final sentence.
Yes, I mean, the phrase I was picking up
Yes,
was
quite,
potentially
quite.
bear responsibility.
Yes.
It's put rather broadly, but it potentially...
It is potentially overbroad, I think, is the point that Lord Brown was making, potentially overbroad if one simply focuses on someone
Yes.
dying in the care of the state,
Right.
as opposed to there being some sort of responsibility.
Yes.
Yes.
The recognition, I think, I'm so sorry.
You could argue that the BAC inquiry was simply an example of an appropriate response to the requirements of Article 2.
What? I can't hear.
BAC inquiry.
Oh, yes.
I mean, I seem to recall the idea is that the state has taken responsibility for the person. I mean, if they're in prison, they're responsible for them. If they're in a mental hospital and detained patients and so on, they're responsible for them. So they've got them under their control. They've got them. They've forced them to be where they are, and they are responsible for their welfare. I mean, that's so. And I think the question is, how far does that extend into people who are, for example, just in hospital, whether they're responsible for all of these people as well, or whether, and so on.
Yeah.
Because when you're responsible, then it may very well be that that the death has come about because you have not carried out, you haven't performed your responsibility.
Oh, yes, and that would also tie in with the final sentence of,
Yeah.
in the quote just above paragraph 92 in Takushis. So we don't dissent from that proposition. Can I come to content then, whether it's a separate species of analysis or it is the thing itself? And emphasise again that it doesn't follow, even if you do decide that trigger is separate from content, it doesn't follow from the mere fact that it's triggered that you automatically have to have a particular type. 4 principles we sought to identify in terms of approach to content. First, there is considerable flexibility to react to the particular context and indeed the particular circumstances of the case. And that was particularly emphasised in the L case. If you could take that up, please. It's at
29.
tab 29 in the same bundle of Takushis. The point being, in effect, that there is not a one-size-fits-all investigation in terms of the content that is required. See, for example, in the speech of Lord Roger, paragraph 77, the Secretary of State is concerned about the financial implications of having to hold an independent investigation in cases of attempted suicide. His concern is entirely proper, as the European Court has recognised. His anxieties may have been fuelled, however, by an impression that whenever Article 2 requires an independent investigation to be set up, that investigation has to have all the bells and whistles of the full-blown public inquiry described by the Court of Appeal in D, sometimes called a Type D inquiry. Nothing could be further from the truth. I respectfully endorse what my noble and learned friend Lord Brown says on this matter at paragraphs 107 to 108. And if one goes forward to those, you can see that Lord Brown is making essentially the same point.
And of course, one's starting from a different point in L, because by definition, being a near suicide case, it doesn't have an inquest.
That's true.
I mean, the starting point for our cases is an inquest. At least it is if you pull the trigger, if you overlook stage one and move straight to content.
That's true, but in order to decide what type of inquest it's got to be, it's as well to bear in mind the base principles, which is why I'm trying to go back to L for that purpose.
Of course.
So that's the first one, and then if you go back from 107 to 108 in the speech of Lord Brown, and one, perhaps just to pick up the final sentence of paragraph 78 in the speech of Lord Roger, then neither is nor can be any single off-the-peg model that is suitable for use in all cases. And to the same effect, see paragraph 96 in the speech of Lord Walker. And paragraph 114 in the speech of Lord Mance.
And Lord Phillips in paragraphs 31 and following, is he not also emphasising the need for flexibility in just the same way?
My Lord, he is. I meant no disrespect exactly. That's a very good one. I suspect I may have been holding that one back for another purpose.
Oh, I see.
But I'm perfectly happy to deploy it there as well. Paragraph 31 of Lord Phillips. I'm sorry, my Lord. I meant no disrespect in not citing that for this purpose. He certainly is making that point. Second proposition. In resource terms, it is necessary and appropriate for there to be flexibility. So resources are relevant. For example, for the reason given by Lord Brown in L in the final sentence of paragraph 106. He says, but it is idle to pretend that money is no object, and certainly the larger the category of near suicide cases, the Secretary of State, or if he's challenged as to this, the court recognises to attract Article 2 obligation, the more imperative it must be to keep the discharge of the obligation within manageable financial limits. So at one end, and indeed the misconception under which all concerned, it appears, in L were operating, was that the moment it was triggered, you had a one-size-fits-all. It was all going to have to be a D-type inquiry, full-blown public inquiry in every case. That, said the House of Lords, was not correct.
Well, again, I mean, it's, an inquest, in a sense, is a full-blown public inquiry. I mean, it's just a question is how wide-ranging it's going to be.
Exactly. And I'm going to... that will be a submission that I will be making, but
I mean, the bells and whistles, my Lord, or rather, I mean, the D-type one, I think somewhere we explained precisely what was meant by that. I mean, that was what was there being contended for. I've lost it.
Oh yes, I think you were particularly concerned as to whether or not...
Oh yes, it's paragraph 103 at the bottom of page 631.
Yeah.
I mean, that's what was in play there. Was it? Did it have to be that? Or, and then...
The short point is it didn't even have to be that.
Quite.
In the custody context. And if one contrasts that with what actually happens even at a Jameson inquest, the contrast is perhaps stark. But even in the custody context, it didn't have to be in every case that sort of inquiry. And indeed, I think my Lord Brown was concerned at least to raise the question as to whether or not the D case was rightly decided in terms of necessary ingredients of any Article 2.
Well, I think we said it wasn't.
You did, 104.
See paragraph 104. Having said that, the third proposition is that, the third basic principle is that the precise content of the investigative obligation is subject to some minimum criteria. Firstly, and in particular, it must be independent. No difficulty in the case of an inquest. And secondly, it must be effective. See in particular Lord Roger, paragraph 78 in L, citing the case of Ram Sahai and the Netherlands, indicating in that Grand Chamber decision, in the quote that is there set out, what is meant in this context by effective.
Leading to identification and punishment, or effective in the sense of identifying shortcomings and making recommendations?
I think both. As you see from paragraph 324 in the quote. Actually, perhaps the learning lessons one isn't included in there, but we would accept on the authority of Armin, amongst others, that learning lessons is an integral part.
Yes. The area in which this has been explored has usually been the area where there's been a question mark raised as to whether the relevant authority has been in breach of duty, which has resulted in the death. And so that's the focus of all these cases, and they're dealing with that situation. But in a modern society, a state will undertake duties for the physical welfare of its citizens, which go far beyond these kind of individual situations, providing inoculation for children and all of this kind of thing. And if you have suddenly a series of child deaths, or deaths of anyone that are unexplained, I would have thought there's a duty to carry out an investigation, see what's happened. Not because there's a question mark as to whether somebody's been at fault, but simply this is part of the general duty of the state to take reasonable steps for the physical welfare of its citizens.
My Lord, again, we don't dissent from that. I'm going to come in a moment to the sort of factors that we say should inform precisely what type in what circumstances. But certainly the public interest is a factor which we will be saying is relevant, which I think is the thrust of my Lord's question. If there are, as it were, unexplained child deaths as a result of inoculation, then that may well call for something very, very substantial. If you have the BSE inquiry, those sorts of deaths may well lead to the need to go beyond even the inquest because of the public interest considerations. And perhaps that leads naturally into the fourth basic principle, which is that subject to the minimum criteria, the particular form of the inquiry that is required is context and fact specific.
I mean, this is the learning lesson justification for the inquiry, as opposed to finding out if somebody is culpable.
Yes. And I think my Lord Phillips in paragraph 31, which was this was the purpose for which I was saving it, in paragraph 31 of L said that different circumstances will trigger the need for different types of investigation with different characteristics. We respectfully agree.
Well, I think Middleton does leave a good deal of discretion to the coroner as to exactly how he conducts his inquiry and what's, at the end of the day, he produces in the form of answers.
And so we respectfully submit as Jameson. But I'll come on to that.
Yeah, but the one thing that none of these principles go to, and nor do those two cases, is what is it that decides, whether you've got to go that step further in terms of your actual verdict or result, or what the jury actually are allowed to say, because as we know, the law is rather restrictive as to what you can say, unless it's an Article 3, an Article 2, by virtue of Section 3 type of inquest.
Well, I'm going to come to explore the precise form of that. I know that's a matter of concern to my Lord, and I'm going to come to that if I may. The question that then arises, in general terms at least, is what are the factors that should then shape the form of inquiry? And the principal factor, we respectfully submit, I hope in alignment with Lord Phillips in L, is what is required in the particular circumstances for the inquiry undertaken to be effective for its purpose. And effective for its purpose means in this context, meeting the Article 2 rationale, i.e. flushing out wrongdoing, ensuring lessons are learned, and so on. And it's not attractive, we submit in principle, for that question to be answered solely or principally by reference to categorising cases into broad types or groups, for example, custody or healthcare. That may create serious difficulties, serious differences of approach between cases sharing relevantly similar features. And the L case indicates that even within particular groups, such as custody cases, there is, for good reason, no right answer, no single form of inquiry. It's also difficult, if not impossible, to be answered in the abstract, because it is a context and circumstance-specific question. But what are the factors that may play into it? First of all, we respectfully suggest the public interest. Lord Phillips, again in L, at paragraph 45, gave an example of a sort of case that might trigger it. Even in the individual case, where, for example, a killing had been in particularly horrific circumstances. He said there will, however, be circumstances in which the internal investigation will not be adequate to satisfy Article 2, where a D-type investigation is required. The public interest may itself require this. In Edwards, the court remarked that the manner in which the deceased lost his life was so horrendous that the public interest in the issues thrown up called for the widest possible exposure. And to similar effect, we say, if one goes from there back to Kushis, my Lord Brown, when he was in the Court of Appeal in Jameson, is cited at paragraph 46 of Kushis. Recognising in similar vein that when a person dies in custody, that is highly relevant to the scope of the inquest. Because the coroner, as he puts it in the second sentence of the quote in paragraph 46, is bound to recognise the acute public concern rightly aroused where deaths occur in custody. So we respectfully submit that public interest is one important factor. Secondly, the nature of the issues emerging during the course of the inquiry. This raises the possibility that one can't actually decide finally on the form of the inquiry at the outset.
So can you just repeat it?
Yeah, my Lord, yes. The nature of the issues emerging. So one can't necessarily reach a final decision as to the nature and scope of the particular form of inquiry at the outset and then say, well, that binds forever after. You need to keep the issues under review. One can, as it were, take the initial investigation analogy in L and apply it to inquests. You examine the issues that are necessary, you follow the trails that are considered to be appropriate, and then you, as the coroner, make an informed judgment as to whether following those trails is sufficient to meet the rationale underpinning the investigative obligation, accountability, the learning of lessons, and so on. If so, there's no need to go further. And that will be the position in most cases because of the width of the traditional approach. If not, you should do so. And see, especially for a description of that sort of approach, Lord Roger in L, at paragraph 79, that reasoning, we respectfully submit, can properly be applied to all forms of investigation of this kind.
At the moment, I'm a little bit lost as to whether there is any form of death which doesn't potentially attract some form of inquiry which has to meet in some way or another Article 2. If there are no categories, and it's all a matter of looking at the facts and deciding what sort of inquest is appropriate, or in a near death situation, what sort of inquiry is appropriate. Does it follow that every death or near death imposes on the government some Article 2 procedural obligation?
Well, I think the answer to that question in principle is the one we were discussing a minute ago, which is that if it's not enough simply for the death to have occurred, nor is it necessarily enough for the death simply to have occurred in the care of the state. What is required is the engagement of potential responsibility of the state.
But what does that mean? I mean, there's always, you can always argue, well, if this death would have not occurred if the alcohol limit had been 0.5 instead of 0.8. You know, the law should have been an inquest to ascertain that years ago, or whatever. In almost any situation, you could say if the government had regulated further, or if the government had introduced and regulated further, the death would have been might have been avoided.
Well, my lord, I'm sure that there may be questions of whether or not one is in the territory of potential responsibility of the state. I mean, there may be circumstances in which that plainly isn't so. I think the thrust of the case law is that if there is applying a relatively light approach to that, and it's not limitless, there will no doubt be questions of remoteness from the death, obvious remoteness from the death, but in that one shouldn't, appears to be the thrust of the case law, and in particular of the reasoning of the House of Lords in L, one shouldn't be, as it were, overly demanding at the stage of trigger, even if that exists as a separate species and form of
I mean,
analysis.
surely the Coroner's Act specifies certain categories of case in which there has to be an inquest, and otherwise there isn't one. I mean, and they're not all cases which possibly engage state responsibility. I mean, you know, I think any death on the roads case you have to have an inquest, and there are certain industrial cases where you have to have an inquest, and some of them you specify in terms under the Act have to be with jurors, and some don't. And I mean, so the state has looked at all this and legislated accordingly.
Yeah.
And it's created different kinds of investigation, different categories, different circumstances, and there may be circumstances for which there's no express provision, but nonetheless call for an inquiry.
Oh, yes.
And I was suggesting it's not simply to find out whether the state has been in breach of its duty in the past. The positive duty may require an investigation into why people are dying or why an individual has died, whether or not it creates a question mark over the conduct of the state. And there's a much wider spectrum, isn't it? Health and safety executive has all sorts of duties of inquiry. If you have an accident on the shop floor, you've got to make a report. All of this is part of the way this country has set about protecting the lives of those who live here.
Oh, yes. And that, we respectfully submit, would be sufficient to comply with any framework obligation. The only reason I was pausing was whether or not, as a matter of Article 2 obligation, which I think was the concern that Lord Mansell expressed, whether or not some of those more, as it were, outlying areas where public concern is legitimately raised, but the state is not in any sense responsible, other than perhaps, I suppose, very remotely through the fact that it regulates all aspects
we
of our
come back
lives.
to the point that when you look at these cases, you don't find, I think, freestanding Article 2 cases based simply on failure to investigate. They tend to be ancillary to a substantive case of being responsible for the death. And what's more, you didn't investigate it properly. Yeah. But that doesn't mean that Strasbourg wouldn't, in an appropriate case, say this country simply failed in its duty to investigate what was happening.
Well, no, that's true. And there's been a recent Grand Chamber.
You've got to have a victim, that's one of the things.
Yeah, you have. Yeah. Well, anyway, that's the second one, was the nature of the issues emerging, so that one has an approach, as it were, which doesn't shut the door on day one. Thirdly, is there an arguable breach of the substantive obligation? That at least is potentially relevant at this stage. If the position on the facts is that there is no such arguable breach of any kind, and as I say, it's a relatively light hurdle, no doubt, because of the arguability of the breach at that stage, but that may be a powerful factor in favour of not expanding the scope from Jameson to Middleton. I'll come back to that aspect in a moment, if I may. Fourthly, relevant to take account of all strands of the domestic process that may have assisted in complying with the investigative obligation. So in the domestic context, there are available in a context such as this, potentially at least, criminal proceedings, various internal investigations. Here we had 2 Board of Inquiry reports, though it might be thought relatively obvious problems with at least hierarchical independence if one was relying on them alone.
I'm sorry, you're dropping your voice.
My Lord, I'm sorry.
This court, I hope, after Easter will be better, have better audibility, but at the moment it hasn't.
My Lord, I apologise. It's entirely my fault. One has criminal proceedings.
Yep.
One has various internal investigations,
Yes.
Board of Inquiry, although if one was relying on those alone, hierarchical independence difficulties potentially. One has civil proceedings, and civil proceedings for negligence have been issued, as I understand it, in this case by Private Smith's relatives, and one has inquest. And one can and should, in my respectful submission, take into account all relevant strands of investigative process, particularly in cases where negligence is the core allegation, or is in effect the core allegation. The question in each case is whether the system as a whole, including both any investigation initiated by the state and the possibility of civil and criminal proceedings, has rendered a practical and effective investigation. And that's a quote from Takushis at paragraph 105. So, in my respectful submission, one can and should take into account as relevant the possibility, even in the context of Article 2, of civil proceedings. As you will well know from the healthcare cases, that possibility of civil proceedings is not merely relevant, but is of considerable importance in terms of the satisfaction of the investigative obligation. Focusing then, finally, on inquest, as we've now identified, in L the issues arose under Article 2 because there hadn't been a death, and so the inquest route wasn't available, traditional or Middleton. The question was therefore whether Article 2 was triggered so as to require more than the admittedly non-independent investigation that had been conducted by the prison service. In Takushis, however, there was an inquest, which was a Jameson inquest and not a Middleton inquest. And the Takushis decision, which we invite you to read in full, is essentially in 2 parts. The first part considered whether the investigation undertaken in a traditional Jameson inquest had been sufficient. And that first part of the reasoning runs from paragraph 39, essentially, through to the end of paragraph 69.
69.
69, so 39 to 69. Yep. And you'll see in paragraph 39, we consider first Mr. Fitzgerald's submissions, he was for the deceased, submissions on the assumption that in this case, Article 2 was not engaged, in the sense we've just described. Put shortly, his submission was that although the coroner correctly decided the question whether there was systemic neglect was a proper subject of inquiry at the inquest, he then concluded that there was no such neglect before hearing the evidence and having called only a limited amount of evidence reached the same conclusion at the end of the inquest. In these circumstances, he submitted there was no proper or sufficient investigation of the system at the hospital. And you'll see paragraph 41, it is not in dispute that the system at the hospital was a proper matter for investigation at the inquest. Bear in mind, this is a Jameson inquest at this stage, not a Middleton one. And then picking it up at paragraph, perhaps don't need to read the remainder of those paragraphs, but you will see from paragraph 49 that the conclusion of the Court of Appeal was that even applying that basis, first of all, under Jameson, systems can properly be looked at, so it's wide enough to include analysis and investigation of systems. And secondly, if you're going to do that analysis, you need to be doing it properly. The second sentence of paragraph 49, such an investigation surely involved investigating both what the system at the hospital was and how it operated on the day in question. The coroner recognised that, but in our judgment did not investigate the system in sufficient detail. And then separately, they then examined the Article 2 issues. And the suggestion that more was needed, that it was necessary in that context to have a Middleton rather than a Jameson-style inquest. And their essential reasoning is at paragraph 105 and 106, where they say, subject to what is said in paragraphs 97 to 103, they agree with those conclusions. These are conclusions set out by Mr. Justice Richards in the Goodson case. It seems to us that however it is analysed, the position is that where a person dies as a result of what is arguably medical negligence in an NHS hospital, the state must have a system which provides for the practical and effective investigation of the facts and for the determination of civil liability. Unlike in cases of death in custody, the system does not have to provide for an investigation initiated by the state, but may include such an investigation. Thus, the question in each case is whether the system as a whole, including both any investigation initiated by the state and the possibility of civil and criminal proceedings and of a disciplinary process, satisfies the requirements of Article 2 as identified by the European Court in cases to which we have referred, namely, as just stated, the practical and effective investigation of the facts and the determination of civil liability. The question is whether the system in operation in England in this case meets those requirements. In our opinion, it does. The system includes both the possibility of civil process and, importantly, the inquest. We can understand the point that the possibility of civil proceedings alone might not be sufficient because they do not make financial sense and may not end in a trial at which the issues are investigated. However, in the context of the other procedures available, an inquest of the traditional kind, that's the Jameson kind, therefore, an inquest of the traditional kind, without any reading down of the 1988 Act by giving a wider meaning to how, as envisaged in the Middleton case, and provided that it carries out the kind of full and fair investigation which is discussed earlier in this judgment, that is, properly look at systems, and which we hope will now take place, in our opinion, satisfies the requirement that there will be a public investigation of the facts which will be both practical and effective. Moreover, the family will be able to take a full part. So the Court of Appeal concluded that it was sufficient to meet the investigative obligation, that the inquest was initiated by the state, it was plainly independent, it was plainly sufficiently public, witnesses would be called, and a traditional Jameson type inquest would be more than sufficient to satisfy the procedural obligation in that context. And it's to be noted, it was a context in which system failure was put at the heart of the complaint. So under traditional Jameson, you can look at systems and should look at systems, and when you do so, you've got to do so properly.
I'm a little puzzled as how we approach the issue, if we approach it as formulated in the Statement of Facts and Issues. Because there it said, the issue is whether the fresh inquest into Private Smith's death must conform with the procedural obligation implied into Article 2 of the Convention. One questions the premise. Obviously, it must conform with whatever Article 2 requires. But the premise that you can put your finger on a particular thing that Article 2 requires.
Right. The answer may be that, in truth, what is being sought in a case like this, where there's going to be a fresh inquest and where there are similar cases backed up in the pipeline awaiting guidance, it may be thought that without being, as it were, unduly restricted by the form of that, what is really sought is guidance as to the correct approach and principles.
Or whether our statutory framework in relation to inquests is adequate to satisfy all the potential demands that Article 2 might have. Because this, I think, is focusing on the point Lord Brown is making. What are the statutory fetters on the coroner? And do they prevent him from satisfying Article 2? That's
In an ordinary case.
well, in any conceivable case. Let's leave it in this context.
I mean, there will still have to be decisions as to whether or not one needs the expanded form. I'm going to come now. I haven't said I'm going to come.
And that was the whole point in Middleton, that one could read down the words in the Act and expand the form to meet the requirements.
Yes.
I mean, there were two problems, as I recall. I mean, one was the construction given to the word how in section 11, 5 B2, which had been narrowly construed in Jameson to mean by what means, and not in what circumstances. And in Middleton, we said, well, that's not going to be enough in the circumstances of this particular case, and you've got to read it more widely. And the other was the problem of the verdict and the narrow range of verdicts. As I recall, those are the two problems that meant that we had to use Section 3 of the Human Rights Act to modify what had hitherto been thought to be the effect of the Coroner's Act.
Well, you're entirely right, but there will still be a question, because the House recognised in Middleton also that it wouldn't be necessary in all cases, or in every case, to have a Middleton rather than a Jameson inquest. There would be cases in which Jameson would be enough. And so one still has to grapple with the question, what are the circumstances in which you have to expand it? But in terms of the difficulties and the analysis of the state of the law, there is perhaps a sort of clear exposition of the applicable law in the Court of Appeal's judgment in Tecutius, which deals with Middleton and deals with the relevant legislation. In particular, at paragraphs 39, which I've touched on already, that's 42 as well, the start of 42. And running through to 42 to 48 are the essential ones of Tecutius, where the relevant passage from Middleton is set out. Note in particular the conclusion between D and E. A verdict could properly incorporate a brief, neutral, factual statement that should express no judgment or opinion. It's between D and E on 474.
I mean, the inhibitions really are at D, aren't they, and just above E. Not the function of a coroner or an inquest jury to determine or appear to determine any question of criminal or civil liability to apportion guilt or attribute blame. And then the verdict, just above E, should express no judgment or opinion. And I mean, Strasbourg says on occasions it's got to do that.
Yes, although there is still...
not on every occasion, but on...
There is still some flexibility as to whether or not it is... well, there's still a considerable degree of flexibility inbuilt within the system. First of all, you may have cases where the coroner sits alone, as occurred in this case, and as we'll see in a moment in this case, was relatively untrammelled as to what he could say, even though it was a Jameson-style inquest. There are some restrictions on what a jury can be invited to do, but as I understand it, even a jury can be invited in a Jameson context to deliver a narrative verdict of some kind. So there isn't, my respectful submission, a great deal of difference between, on the one hand, Jameson and on the other hand, Middleton.
And as I understand it, there's an ongoing civil claim in this here, is there not? Or have I misunderstood?
There is an extant civil claim in negligence.
That's what I'm saying.
There is.
Yeah. And I mean, that's relevant too.
It is, my respectful submission.
Well, that's why I asked you for some help eventually on the question as to how that claim, a negligence action, interrelates with any substantive Article 2 claim.
My Lord, I will do that. Just on the restraints, therefore, one's got the two. We've got how and in what circumstances, and we've got a potentially narrower verdict. But bear in mind also that when considering those restraints, that there is, in any event, under Rule 43 of the current rules, a power to make recommendations in order to prevent recurrence of matters which threaten public safety or the safety of a group of the public.
So those don't form part of the verdict, but they can be recorded and
They can be recorded and transmitted to the relevant public authority by the coroner.
Yes.
And again, we'll see in a moment, that's exactly what happened in the first inquest in this case. Bear in mind also that in relation to a Jameson inquest, systems are proper to be investigated. And if one looks at Appendix Part 2, Volume 3 of 3,
Sorry, Appendix Part 2.
I'm afraid they're very confusingly numbered, but it's Appendix Part 2, 3 of 3.
3 of 3.
3 of 3. There are three blue volumes within Part 2 of the appendix. We're after the third one, which has within it page 950. Uh, 950, halfway down the page, is in effect the start of the coroner's summing up, or it might be thought more accurately, judgment. And that runs through
No jury here.
no jury. That runs through to page 962, but it is worth, if only very briefly, just flicking through those pages to see the sorts of things that he can do.
So he's got his verdict at page 961, is that right?
Yes. He declines in his exercise of discretion to use the short form verdict. Says he's going to give a fuller verdict. As you see at the bottom of page 952, in my view, this is a case where a narrative verdict is appropriate, and I shall begin by saying this. And then he specifically addresses C953, second full paragraph. The question I've returned to time and time again throughout this inquest is, why was it that Private Smith died when he was working with many other soldiers in the same conditions? This is a question I will try to answer.
Sorry, where's that?
Sorry, 953, second full paragraph. And some pretty trenchant views being expressed. If one sees, for example, the examination of his within UK call-up stroke training processes, and whether or not there was a proper assessment of his fitness to go out on this operation. You'll see 953, the final paragraph on that page, over to 954, culminating in his expression at the end of that paragraph with the words, that in my view is simply not acceptable.
Well, Mr. Eading, I'm still a little puzzled as to precisely what the object of this exercise is. In this particular case, there are going to be no restraints on what the coroner can investigate or what he can say, as I understand it. But a general question is posed for us to answer. Now, is the general question, is our statutory framework for dealing with inquests adequate to cope with this type of event? Is that what we should be focusing on, or what?
I mean, there may be a constraint here. Unless Article 2 demands it, the coroner is not entitled to use, if and insofar as there is a distinction between them, a Middleton-type result to it instead of a Jameson-type result. It is only if Article 2 requires it that he can. Otherwise, he is constrained. That's the point that respondents make, and it seems to me it has to be right, doesn't it?
Well, I agree with that.
Yeah.
I agree with that. There is that potential restraint. The question is, what principles should guide this coroner and other coroners in similar positions in determining whether or not it's one side of the line or the other? That's why I've sought to go through the underlying principles.
Right.
And that's why I'm now engaged on this exercise, which is designed in particular to show you the sorts of things that can be done even under a Jameson inquest. But the answer ultimately to the question that is raised in this case is, it all depends on the circumstances. What the coroner should be doing is starting off applying the ordinary approach, the Jameson approach, investigating what can properly be investigated under the Jameson approach, and if and to the extent, it's obviously going to rise in this case because of the concession that's been made, but in a future case where it does arise, if and to the extent that he bumps into, as it were, a difficulty in terms of scope to deal with that to start off with, then he will have to address directly the question whether, in order to make it effective, which is the ultimate and driving yardstick, he needs to go into that further area, then he has to address the question at that point. Likewise, when he comes to consider how he ends up disposing of it, if he decides that there is sufficient flexibility within the Jameson and ordinary process to operate the procedures set out in the Act, that in itself is sufficient, as he concluded it was in this case. If, on the other hand, he concludes, I can't render the investigation which I'm undertaking sufficiently effective to meet Article 2 rationales, then I will need to consider whether or not more needs to be done. As I say, in this case, what he did was to, sitting on his own, was to consider that it was sufficient for him to deliver what was in effect a brief but pithy judgment with the verdict attached to it in the form in which you see it at 961.
So, suppose we were against you on the first issue, and therefore it was within the jurisdiction and therefore presumably potentially Article 2 engaged. In that situation, what is it you want us to say about the verdict, or about the inquest? And what help are we to give?
Well, my Lord, the assistance that I would invite you to give is to set out the principles on the basis of which, as I say, doesn't arise in this case because of the concession, but the principles on which coroners in similar cases should be making the judgments that they might need to make for the reasons that my Lord Brown gives, as to the differences between the forms of inquisition or verdict, to give guidance on the principles that should apply when they're making those decisions. And that's why, as I say, I've sought to go through the principles and the approach, but in my submission there's not a great deal more that you can do in this case, because it is a fact-specific thing.
I mean, as I'm just trying to see what you say is a broad guidance, and if it's a situation where there's an arguable breach of a state duty to look after in any way, whatever, and I think the other criterion I gathered from your submissions was that a coroner might consider whether the system as a whole, other aspects, had satisfied or were likely to satisfy the need for a practical and effective investigation. I mean, those are two very vague criteria, and I'm just puzzled to come back on a point I made before a little about how they relate to your case, because I thought your in your case, you were trying to actually say that the Middleton type inquiry was really defined by reference to certain categories of case, but you disclaimed that today. I mean, that's why your case is full of references to the distinction between this situation and the custody situation and so on. But you disclaimed that, so we're left with rather vague criteria.
Well, my lord, we don't disclaim the proposition that there isn't in this context a positive obligation on the state of the Osman kind, but we say that nevertheless, although that is a relevant factor, it isn't the only one. And in terms of the scope of the inquest, it is a relevant factor, but no more than that.
Well, obviously, if there wasn't any potential state responsibility at all, then presumably your argument would be there's no question of a Middleton-type inquiry being necessary.
If that is the conclusion that is reached when the coroner comes to consider the matter in the future. But we don't accept, and part of the principal reason that we're here is because we are concerned about the possible width and ramifications of the reasoning of the courts below, which was fundamentally centred on, first of all, the analogy as between, as it were, conscripts and ordinary soldiers, and secondly, on the proposition, certainly appearing most clearly from Mr. Justice Collins' judgment, that all soldiers, in effect, had owed to them the Osman-type obligation in all circumstances. And those issues are a matter of real concern to the government for very obvious reasons, simply because of their breadth. We don't, however, say that those are necessarily, although relevant, potentially relevant in this context, that those are necessarily central to the disposition of it. But we are very concerned about the, first of all, that's the link between conscripts and ordinary soldiers, and secondly, the suggestion, as I say, that all soldiers, simply because they are soldiers, are subject to that Osman-style protective obligation. Lords, can I come briefly to that issue?
Just before you move on, I'm still not absolutely clear whether you're asking us to say any more than was said in Middleton in paragraph 36 about what happens if one is in a Middleton inquiry, because paragraph 36 was giving a good deal of latitude, as I understand it, yes, to the coroner to decide exactly how to conduct it. Indeed, I think it begins by saying that it may be the traditional short form of verdict will be enough.
Yes.
So the margin between the two types is quite difficult to discern. And it may be until you embark on the process, even if you're in a Middleton case, you won't know where you're going to end up, and you may actually end up in the same position as in the Jimison inquiry.
Yes. My Lord, I'm not sure I am saying much more than that. I mean, the fact of the matter is you can't make that judgment, is my submission, until you start exploring the issues. Middleton doesn't say you need to have it in every case. It says effectively keep it under review. In some cases, Jamieson may be enough. In others, Middleton will be required. What truly drives that process is what is necessary for the purpose of ensuring that the investigation is an effective one.
Yes.
That is governed, at least in part, by the rationales that underpin Article 2. Do you need to go further? And that is why it does become relevant to assess just how wide a Jamieson inquest can go, yes, which I know is a subject of detailed consideration by this House in Hurst, for example, where effectively the conclusion was that the scope of Jamieson versus Middleton really made little odds. He has to do it fearlessly and fully under Jamieson, so the scope was essentially the same. There may potentially be differences as to inquisition or verdict, but as we see from this case, there are circumstances in which he can perfectly properly and happily deal with it on a Jamieson basis without going that much further. So as I say, our concern here is that nothing in the reasoning of this court, or indeed of the lower courts, should suggest, as it were, that there is owed to soldiers the positive obligation, the Osman-style positive obligation. That raises a question which doesn't arise directly in this case, and is certainly going to arise in a series of cases that are in the pipeline, and it does raise very difficult issues. But that arises, if anything, only incidentally in this case, and it may well be, indeed we would invite the court to conclude that it doesn't actually need to go into that issue. and indeed it might be thought to be inappropriate to do so in a case where it doesn't arise directly. There will be cases, I say, in the pipeline which will raise that issue very directly. And that will require consideration of the circumstances in which the obligation is owed.
When you
and so on.
refer to cases in the pipeline, you're obviously looking to the future and what's coming. I see that we've got one section of the Coroners and Justice Act 2009 which is not yet in force,
Yes.
Apparently. Is that something we need to know about in order to decide this case? Well, in order to look forward to the future. Is Section 5 of the Act the only one that's going to be of any importance in this?
My Lord, it is, because the relevant part of the new Act is not in force currently. The date for its commencement is, I think, envisaged to be April 2012.
Oh, as long as
As long away as
and it will apply only to deaths after that date, will it?
That I will need to check. No.
Or at any rate, inquests after that date.
Can we check that? I'm not entirely sure what the answer to that is.
As I understand it, that actually simply preserves the status quo.
It does, because it's cast in a form that says do it this way unless you're required to do it by convention rights in the other way. But I will check whether it applies to inquests going forward or simply deaths that occur after. But it's on any view some way off.
Right.
If the implementation date is April 2012, which as I understand it is.
Sorry, but can I be clear? So you're saying that if the case, arguably engages a substantive Article 2 breach, then real questions are going to arise as to what should be the scope both of the inquiry and of the actual inquisition, the return verdict. But we should shut our eyes to all that for the purposes of these proceedings. Is that what you're saying?
Well, what we're saying is that if it's going to arise and needs to be determined, it is a matter that will need to be grappled with by the coroner on the basis of all the facts that exist, and it's a matter that he will need to keep under review as the inquest goes forward.
You're really applying paragraph 36 of Middleton then, are you?
And no more than that.
As I understood it, that was the purpose of my question earlier. You're not asking us to, as it were, revise what Lord Bingham was saying in that paragraph.
No.
You're accepting as it stands.
No. As I understand, the respondent's case is that this must be a Middleton inquest.
Yes.
And we're saying it may be or it may not be. But as a matter of approach, there are the principles that we say should inform that in a future case.
You said a moment ago we don't have to decide and we should avoid the question whether the government owes an Osman-style positive obligation to all soldiers. Can you clarify that? Do you mean an Osman positive style obligation to all soldiers in respect of sunstroke or heat? Because, and if you mean it generally, I don't understand what you're saying, because the Osman obligation arises in a specific context where a state knows that someone is particularly at risk, in that case, from someone else. Are you...
Real and immediate risk, I think, is the concept.
Yes.
Well,
so what are you talking about when you say you don't accept the government owes an Osman-style positive obligation to all soldiers?
My Lord, can I explain?
Yes.
I'll try and make it a little clearer anyway. To date, the Osman approach has been applied in limited situations. It's been applied to a real and immediate risk to an identified individual from the criminal act of a third party, of which the state should have been aware or was aware. And Officer L, the case in the House of Lords involving anonymity orders in the context of Northern Irish public inquiries, indicated the tightness of the concept of realness and reality and immediacy. But it's been applied in that context. It's been applied to the risks of murder by another prisoner or suicide in the case of those in the custody of the state. It's been applied to the specific situation of conscripts committing suicide, where it might be thought, because of the nature of conscription, they are at special risk of suicide in case of those called up involuntarily by way of conscription.
I think it was undertrained people, undertrained, unstable people being given lethal weapons. Wasn't it? That was what the case was about.
Yeah.
That's certainly one of the cases,
Yeah.
certainly.
I missed
The one
that.
where you use the French and I use the English.
We do.
Yes, the Ataman and killing.
I missed the description of that. It was.
It was providing well, people were given weapons when they shouldn't have been given weapons, and as a result of which someone died.
And this is a UK case.
No,
This is a Russian case.
Right, I see. Yes.
Somewhere east of Vienna. Anyway.
So conscripts, we're talking about Russian conscripts.
Turkey.
Yeah,
Turkey.
One of them's Turkey.
One of them's Turkey, I think.
Ataman.
Killing.
Turkey. And it's been applied in Savage and extended in Savage to those who are detained under the Mental Health Act, who are known to have been or should have been known to have been at risk of suicide.
Well, that comes under suicide of those in custody of the state. Mrs. Savage
Yes.
was in the custody of the state.
Yes. And it's been
We
applied
left open the question of other patients,
categories.
I think.
And it's been applied in some other categories where there have been multiple disasters or disasters resulting in multiple deaths, where the state was in effect held to be criminally liable.
Oh, is
Such
that the
as on a-
Turkish
on a
rubbish
yield-
dump? That's
on a
on
yield. Exactly.
the
The meth-
unpronounceable
on a yield.
Turkish rubbish, yes.
Yes, the methane explosion. But it's not, we submit, and hasn't been taken to be a principle of general application. It isn't coincident with, for example, UK principles of negligence. And bear in mind, in principle, that if it applies to the armed forces, it applies not just to UK armed forces, but to all armed forces across the ECHR. The fact that it doesn't apply to all cases that are equivalent to negligence is evident from the Powell case, where where it was indicated, as the House of Lords noted in Savage, that mere casual acts of negligence would not be sufficient to engage the responsibility of the state. And it follows from that that even in circumstances which are inherently dangerous, such as operations, medical operations, it doesn't always apply in that context. It is not, we respectfully submit, likely to be applied or extended because it does involve the state being called to account independently of the existence of any private right of action being called to account on the international stage.
What is the circumstance we're envisaging, Mr. Eady, in this discussion?
Well, we're envisaging the question that we're asking is whether or not, in all circumstances, soldiers who are operating abroad in potentially dangerous situations are subject, without more, simply to the obligation under Article 2 on the state to take such steps as are reasonable to protect them.
Well, I mean, could you just give us a concrete example? I mean, I find it very difficult to follow. It's abstract.
As I understand the case against me, it is that there is, because of the inherently dangerous nature of military operations, there is always an Article 2 protective obligation on the state to take, quote, reasonable steps, whatever they may be, to protect soldiers. That's as I understand.
Well, supposing, for example,
the
supposing there is a soldier,
yes,
and there is a terrorist pointing a gun at that soldier's head, and an officer belonging to the army can shoot he's there and he can see this and he can shoot the terrorist to prevent that. Is there an obligation on the state to do so, to protect the soldier?
Well, we respectfully say not under Article 2. We say you can't reason from the proposition that real and immediate risk, which will arise in a whole variety of different circumstances in military operations, we say that obligation shouldn't transpose into that context. It should be restricted to those cases where it's already been applied in the existing Strasbourg case law, where people, for example, are in custody and one is dealing with the prevention of suicide. There are really serious problems in my submission with seeking to apply it in a context such as military operations abroad, even of the extreme type that my law gives.
The obligation of the police, of course, is simply to go around policing their area. But if they actually come across a person who is standing there with somebody holding a gun at his head, I rather think the police officer has an obligation to intervene to prevent that. Even though, of course, that's what an Osmond-type operational duty arises, because you're there and it's happening in front of your eyes. Now, I can't quite understand what the difference is between that and the situation which I've posited with the army officer.
Well, my lord, the difficulty is that the difficulty in my submission is that if you reason for that sort of extreme example out to the broader proposition that therefore all that is needed is to establish, in effect all that is needed is to establish a real and immediate risk to the individual, in military operations you will end up in a position where effectively you just have a freestanding obligation to take reasonable steps, whatever that may be. Now that isn't subject, for example, or I say it isn't subject, it would be a matter for serious argument whether it is subject, but it isn't obviously subject on any pre-existing Strasbourg case law, for example, to principles that operate in the context of the domestic law of negligence, such as combat immunity. And there is a real question about whether or not it is appropriate and, in principle, sensible to apply an approach that simply says real and immediate risk, soldiers, always going to be a real and immediate risk, therefore reasonable steps. Now, of course, to some extent I recognise that one can mitigate the rigour of that by recognising that reasonable steps is a context-specific thing, and reasonable steps in one context may be one thing and in another context may be another thing. But there is in my submission a real difficulty with simply saying Osmond transposes, because you will end up in a situation, as is occurring on the ground, with very, very many cases where it's simply alleged, without any of the constraints that have been built up under the domestic jurisprudence, combat immunity, those public interest things that feed into duty of care, which go in effect to justiciability, not merely to tailoring the obligation by reference to a concept of reasonableness, you end up then creating really serious difficulties with the correlation between those two. Is it enough, for example, if Osmond applies, is it enough simply for someone to turn up and say, I'm a soldier, take this individual, suppose someone in the football stadium was killed by mortar fire, or whatever it may be. And they are in an inherently dangerous place. There is a very good reason, as appears from the Board of Inquiry report, there is a very good reason why they were in this stadium. They were in the stadium in Basra because Basra had just been taken over and they wanted to show that they were there. They wanted to create a presence. Why is it necessary? Again, it will be said, well, inherently dangerous, he'd been sent out into the desert to go and patrol. Again, does that just simply give rise to a reasonable steps obligation?
If you take the base, is there no duty under Article 2 to protect the people on the base?
My Lord, in my submission, the obligation doesn't arise in the context of military operations at all.
In Northern Ireland either?
No, in Northern Ireland either.
I mean, we don't need to go to Basra to raise the issues you're discussing at the moment.
My submission is not. My submission is that the Strasbourg case law has recognised very narrow circumstances in which this sort of operational obligation will arise. I fully recognise that soldiers in Northern Ireland or in Basra have a cause of action domestically in negligence and can come to the English courts subject to all the restraints and constraints inherent in the principle of negligence, including, for example, combat immunity, which is a matter of...
Forget the operational obligation for a second, just the general structural obligation, the obligation to have...
well, my Lord, there are...
To have the base properly protected.
My Lord, I'm sorry, I don't want to be taken to be going further than I am. There is in the positive obligations in Article 2 in any event, even in the healthcare cases, what I call a systemic and framework protective obligation. And so that arises in any event.
So
they are protected by the necessity to have safe systems. What we're talking about is something much more individual.
So do you
and
say
specific.
that in this particular circumstance, just as I'm clear, Edie, you say that the protective structure, the structural obligations, the systemic obligations, do apply?
Yes.
In the base.
They do apply. They're acknowledged to apply as a matter of...
But not this particular operational one. That's your...
Not this particular operational one. That's where we draw the line. We accept that, and you will appreciate that the positive obligation to provide a framework of systemic protection goes relatively far. It applies to ensure that there are safe systems under which they are operating.
Well, this was the Turkish rubbish dump, wasn't it? That was a general systemic thing, wasn't it? Rather than a known risk to a particular individual. That was why I was a bit troubled by your listing all of these cases under one heading, when in fact there are a number of different types of obligation, as was made perfectly clear in Savage.
Well, my lady, as I say, we accept that the framework obligation, the systemic obligation, does apply. It applies in the healthcare context, which
extends to equipment, does it?
Could extend to equipment.
But what this conversation appears to me to illustrate is that the question, what kind of inquest you have to have, is really concealing a more fundamental question, what kind of duty is owed? If a duty is owed, then the inquest has got to investigate whether the duty is being complied with.
That's right.
But the seminal question is, what's the scope of the duty that's owed to soldiers? And you're saying, really, we shouldn't be going into that.
Well, there are questions as to how far.
Yes.
Perhaps you should really be suggesting that issue 2 doesn't arise in this case and we shouldn't address it at all.
Well, the difficulty with that is that, as Lord Phillips rightly points out, that our submissions do at least acknowledge, for all the softening from the way it's put in the case, they do at least acknowledge that it is a relevant issue at the context stage to assess whether or not there is an arguable breach of the substantive obligation. And that does require at least some examination of whether or not the substantive obligation exists, and if so, what it is. But on that, our position essentially is we accept, in the line of all the healthcare cases, plainly, that there is a framework obligation which includes systems. What we don't accept is that the Osman-style obligation to take, as it were, all reasonable operational steps to protect particular individuals applies in a context such as this.
I mean, I think does Osman really stand for that? I thought that Osman stood for the proposition that if in a particular case you knew that there was a particular threat, then even if your general system was good, you had to react to the particular threat. It would have to be out of the ordinary.
My Lord, yes.
And I mean, why shouldn't that be common sense? If for example, they knew that a particular vehicle was completely unsuitable, hadn't got any armour on the top, it had all been stripped off, you wouldn't send someone out in it. And
well, so that might fall within the systemic obligation in any event, because it would relate to equipment.
Just because an individual is in danger, immediate danger, let's assume he's strayed into a minefield and has injured himself, and everybody else in his unit can see he's there, and he needs to be rescued. But would Osman demand that somebody goes out and puts himself in danger too and rescues him? I mean, many brave people would do that, but I'm not sure that Osman would drive you to that.
We would submit not.
That's what's reasonable. I mean, that's what Osman says,
therein lies the issue. The question is whether it's a principle which operates on the basis of the restraining effect of the concept of reasonableness, or whether it is an area in which the duty isn't owed. And if one casts it in terms of domestic negligence by way of analogy, the question is, are you going to focus on the standard of care and potential breach of the standard of care and operating that as a restraining principle, or are you going to focus more on the existence of the duty of care in specific situations? I mean, I keep coming back to combat immunity, which, as you can imagine, is a subject which is uppermost in the concerned minds of those who instruct me.
And what do you mean by that exactly?
But what I mean by that is that in the domestic law of negligence, in certain situations where, and there's an argument about the scope of it, But in certain situations where soldiers are engaged in dangerous military operations, the doctrine of combat immunity will operate to prevent the duty of care being owed in the first place.
Yes, I have never come across this one. Could we, are you going to show us this?
My Lord, it's in the Mulcahy case, which is, I don't think anyone disputes that there is such a doctrine in domestic law, but the leading authority on it is Mulcahy.
117, is it?
117, exactly. I can see from the head note the nature of the court's decision.
Section 10 of the Crown Proceedings Act.
Section 10 of the 1987 Act, is it?
Of the Crown Proceedings Act. So 7. I'm just looking at page 741.
Yes, there's not.
Is that not?
That's a separate doctrine. That's a doctrine of.
Well, that used to protect the Crown entirely, but that's all gone.
Yeah, that's a doctrine of Crown immunity.
That's history.
The passage. It's a paragraph 74, page 743. Under the title The Appeal. And it runs through to the end, 749 at E express the conclusion to the court. Yeah, so the principle is really 748G and following, and then 750, again at G. And that's separate from Crown immunity, which, as my Lord Brown points out, is now gone. But nevertheless, the matter of the domestic law of negligence.
I mean, it's a policy decision, it's like Bancolli and so forth, but in this differing context, that it's best not to have a duty of care arising at all.
It is, but the live question will be whether or not, and if so, in what form, that can be transposed into Article 2. So the question will be, that I'm sure that the case against, I'm not sure the case probably already is against the MOD. Here we are, we're in Article 2. We're not in, we may have a freestanding cause of action in negligence, but we say the claimants, that if you're under a separate and independent obligation under Article 2, there's nothing to allow you to rely upon the existence of combat immunity. So that, for example, if soldiers are engaged in what would fall within combat immunity, military operations where they were seriously at risk, there's a firefight going on, combat immunity would not merely say that conditions the nature of the reasonable response. It would say, don't go there as a matter of, in effect, justiciability, because it's inappropriate to do so. And that, of course, I fully accept, is based on English public policy reasons hammered out on the anvil of negligence cause of actions over the years to determine its proper scope and so on. Those sort of restraining features don't exist, so it's understandable, perhaps, and the public interest features which underpin it are relatively obvious. The concern, in essence, is the invidiousness of having to enter into that sort of territory, the danger that it would create of defensive military decision-making in circumstances where you might have to make on the spur of the moment very difficult decisions in a thoroughly stressful environment involving a war zone and warfare. The question would then be, does that apply over? As I say, it's a very simple thing for the other side to say, it's Article 2, look at Osman, real and immediate risk, every soldier engaged out there is at real and immediate risk because people are firing at them all the time. Therefore, the only question is reasonable steps. And we say, caution, caution. That is a matter which will have to be argued out in future cases. If you do have to go there, we respectfully submit that it is more than sufficient under the ECHR for its purposes that there exists, as we accept there does, a principle which provides for a need for framework systemic protection, and that there is no need or warrant to extend that to include the sort of personalised, real and immediate risk that Osman represents.
So coming back to question 2, it really is concealing this more fundamental question. And the difference between a Middleton and a Jamieson inquest, as I understand it, really boils down to what the coroner decides he's got to investigate. Sometimes the only real question, or perhaps a seminal question, is why did the individual die? Let's go away from the battlefield. A schoolgirl dies of an overdose of sleeping pills. Question 1, did she commit suicide, or was this an accident? If suicide is the answer, then the coroner may say, well, actually, I think I ought to investigate why it is this girl took her own life. And you get into bullying at school, which may raise questions of whether the local authority or the school was taking proper steps. And so the inquest will extend not simply to, well, this was suicide, but going further. If, on the other hand, it was an accident, well, then accidental death may be all that needs to be said.
Well, yes. I mean, I think one may need to, as I say, I accept that one may need to get into this issue.
It's not two different types. I mean, Middleton's extended the scope of what the coroner can look into if the facts are such as to require for that particular type of inquiry.
Well, that's why I made the submissions I did about the principles that are applicable. But you'll appreciate the concerns. I mean, to some extent, it's a tearing of the soul point, because on the one hand, we recognise and assert that it is a relevant factor that there has been, if it's clear that there's been no arguable breach of a substantive obligation. But on the other hand, we are deeply nervous, for reasons which I hope will be clear, in the court embarking on a decision as fundamental and important as whether or not this sort of obligation is owed in the time of war and in time of military operations such as these, in circumstances where in truth it doesn't arise directly or may not be thought to arise directly on specific found facts. That's the nervousness.
But I mean, are you saying that Osman is the only sort of breach of substantive obligation under Article 2?
No. I'm accepting that there is a framework systemic obligation in place already.
But assume that there's an arguable case for a breach of that. I mean, why?
Well, then that might be enough to expand if it needs to do so.
Why do we need to decide if it's Osman or the other?
Well, my lord, you may not do, and the coroner may not do. If he decides that in the circumstance of this case he can go wherever he wishes to go and he can give whatever judgment needs to be given or verdict needs to be given, then he will not need to go there. As I say, part of the reason we're here, I don't want to keep repeating it, is because of a concern that the Court of Appeal's reasoning in this case, which led them to where we are now, has caused others in the substantive obligation context to say, right, that's an implicit acceptance of the existence of this very broad and wide-ranging obligation.
I noticed in Mulcahy, not only was there no duty of care, but they held that he didn't have a cause of action for a failure in the system of work, safe system of work. Yet, as I understand it, you sort of go along with a duty to provide a safe system.
Well, my lord, we acknowledge that there is the obligation
So
to
it's
receive.
not the same as Mulcahy in that sense.
Well, it may need to be conditioned by, I confess, I haven't thought through, but it would need to be conditioned by
I find
concepts
this
of combat
subject-
immunity and whether or not it applies to deal with that. But
I suspect the unpredictability of military operations makes it very difficult to have a safe system of work in that sense. I mean, you're talking about systemic in a broader provision of proper equipment, proper instruction, and so on, so far as you can do. But military operations surely are essentially unpredictable and to a large extent uncontrolled, and you can't have a system of the kind that Mulcahy may have been talking about.
yes. The question, as I say, is where that leads. Does that lead you to an obligation which is conditioned by reasonableness, or to something more fundamental, the duty shouldn't apply? And you'll bear in mind, of course, in any event, that under the Strasbourg jurisprudence they repeatedly emphasise, sometimes in the context of the duty not arising, sometimes in the context of qualifying the reasonableness obligation itself, to the need not to impose disproportionate and unreasonable burdens on the state.
See, one of my difficulties is disentangling the systemic from the Osman. I mean, take a situation, you're in a base in Iraq. It's vital to go and send some people out to that sniper post which is firing at your base, okay? All you've got is some depleted vehicle. You haven't got a proper protected vehicle, you've got a Land Rover. Now the question is, do you send these people out? Where's the balance of advantage lie? Do you send these people out in a not as good, a suboptimal, I think is the word they all use these days, vehicle to go and do the business with the snipers, or do you sit back in the base and let them fire at you? I mean, you know, what you investigate, if you send them out, is that an Osman situation, because there's a real and immediate chance that they'll cop it as a result, or is it a systemic failure?
Well, Lord, my submission that would be, that sounds very like an Osman situation. I mean, there will need to be a dividing line drawn between the two.
But I mean, it may be plainly the right thing to do to send them out, but the trouble is the systemic failure which leads to your having had to do so in with a suboptimal equipment.
Well, that may, I mean, it comes back to the point that Lord Roger made. It may be that even in the context of that, when the argument is had under Article 2 on concrete facts, it may be there will need to be argument as to whether or not even that systemic obligation, to the extent that it is owed, is in any event conditioned by the sort of features that my Lord identified from Marquet.
What I have difficulty with, Mr. Eady, is I'm not aware of any case where it's been held that somebody owes a systemic obligation where he wouldn't also owe the operational, as they describe it, because the way the cases describe it is the difference between a systemic system of work, so to speak, or system thing, and what they call the operational duty, the systemic duty, the operational duty. I'm not aware of a case where it's been held that anybody is under the systemic obligation, but not under the operational one. But that seems to be a distinction which I would find your position easier to understand if you were saying, we're not under either, than saying that we're under one but not the other.
Well, my Lord, it may be that the resolution of that is the level of height which one imposes on the concept of systems, whether the framework which exists generally is sufficient, and one should avoid, for all the reasons that underpin the need to avoid the Osman obligation, one should avoid too low grade, as it were, or detailed an acceptance of the concept of systemic protection and framework protection. Otherwise, I'm nearly done. It's 1 o'clock.
Yes, we'll adjourn until 2. We're going to sit until 4:30 today, and we'll sit at 10 o'clock tomorrow, and if necessary, continue to 4:30 tomorrow.
I'm grateful.
In this case, 104 to 106.